So we were discussing this we have started our journey in CPC with the writing of the plaint, because when a civil suit is to be instituted, it will be instituted by filing a plaint. So the first and foremost question is, how will you draft a plaint? What will be contents of the plaint? What particulars to be taken into account? Who will draft the plaint? How will he draft the plaint? Now, what particular things have to be taken care of in the plaint? Now, what is cause of action in the plaint? Because cause of action is the very soul and heart of the plaint, on the basis of which relief can be claimed. So, we have to start from here. I hope when we met last time, I told you regarding certain things. I have been telling you little bit on all points, and I said basically, now just going into that earlier things which we discussed, I said that what is basically this plaint. Now we'll raise different questions and we'll try to answer them. What are this basically questions? So we'll be raising those questions which is required to be understood for writing a plaint. So first and foremost question will come up in your mind, what is this plaint all about? ये plaint होती क्या चीज है, क्या है? तो मैंने आपको शायद बताया था कि plaint is a private memorial tendered to a court. It is a private memorial. आपने कुछ लिखा, private memorial इसलिए कह रहे हैं, private memorial tendered to a court, which the person sets, where the person sets forth the cause of action. So cause of action आना चाहिए वहाँ, exhibition of an action in writing. Is this clear? So what is basically plaint in very simple terms? वहाँ आप अपनी बातें बताते हैं और कोर्ट से कहते हैं कि देखो भाई ऐसा है कि मुझे इसमें ये रिलीफ चाहिए आपसे. Is this clear? So if you are asked a question, no, without being technical and legal, you can answer it very simply. If you are asked a question, what is a plaint? So you start your journey from here. So you say that plaint is a private memorial setting forth the cause of action. Setting forth the cause of action and exhibition of an action in writing. That there is cause of action, I have this right and court has power to grant me this relief and I seek this relief. So basically in this plaint you are required to aver the cause of action, the court's jurisdiction and the relief sought. Now for common understanding, it's very simple. You will show the cause of action, you will show that the court has got jurisdiction, and you will say that this is the relief which I seek and you can grant this relief. That's all. बहुत simple है, बहुत simple है. So plaint is basically a private memorial setting forth the cause of action and seeking an action from the court. And there you exhibit before the court that, see, this is the cause of action, this is the jurisdiction of the court, and this is the relief which I am seeking. Now the second question is, who will write this plaint? अब आप question raise करो और उसके answers करो. This is the best way of learning the things in very simple. Now question is, who will draft the plaint? Who will draft the plaint? Who will draft the plaint? So basically I told you also, which I am again sharing with you, that whenever a common person, a common man has a legal problem, he wants to seek a legal solution by court. So he doesn't know law. So he will knock the door of a lawyer and lawyer has to draft the plaint. So basically if I ask the question who will draft the plaint or who is the author of the plaint or who is the owner of the plaint, in that sense, I will answer that there are two persons. Counsel. Counsel will draft the plaint, because we are not aware exactly as a common person that how it has to be done. And the plaintiff, the person who has gone for seeking redressal of his relief, plaintiff kaun hai? One who files the plaint, one who seeks relief from the court, seeks relief from the court of first instance. Always you are required to visit the court of first instance, section 15 CPC will come to that. So सबसे निचली अदालत में आप जाएंगे जो आपके jurisdiction में आता है. Now counsel will draft the plaint and plaintiff will inform him about the facts. Plaintiff will inform him about the facts, about the matter and facts, on the basis of which a lawyer will draft the plaint. बहुत simple भाषा में, a lawyer will draft the plaint. Because plaintiff is not well versed in law, so always he will seek help of a counsel, a lawyer. So in this sense, what happens, that there are two basically persons involved in the drafting of the plaint. One is the plaintiff, that common man, and another one is that legal man, that is a counsel, who basically drafts the plaint. So there are two kind of authors of the plaint, or two kind of owners of the plaint. One is that person who is seeking the redressal and relief, that is the plaintiff, and another one is counsel. Plaintiff has to sign and verify the plaint. It is his averment. It is his statement through lawyers. So in that sense, plaintiff is de jure author of the plaint. Plaintiff is de jure author of the plaint. He has to take care of what he says is correct. Obviously, now on the question of law, he cannot say that, and that is why two kind of verifications. Now, one on the basis of his own knowledge and another on the basis of information given and belief, which is created in his mind by the lawyers. कि जो मैं बता रहा हूँ इस कोर्ट को jurisdiction है, limitation से barred नहीं है, कोर्ट को jurisdiction है, वो तो lawyer ही बताएगा. Only lawyer can tell this. The common man doesn't know this. So that is why you see two kinds of verification. So there are two authors of the plaint. One is de jure author, that is plaintiff, and another is de facto author, who is the counsel. So de jure author and de facto author, that is the counsel, the lawyer. Is this all right? Now you are clear what is the plaint, who is the author of the plaint. Now when you go to write the plaint, then you have to know that how this plaint has to be drafted. So I told you earlier, and I'll be repeating it time and again, that for writing of the plaint, you are required to know the rules of the pleading. And where are the rules of the pleading? It is in order 6 of CPC. For writing of the plaint, you are required to know the contents of the plaint. Where it is written? Order 7, Rule 1. Basically, particulars of plaint are described in order 7, rule 1 to 8. देखिए कैसे याद होता है, तो आपको ये ध्यान होता रहेगा, बार बार करेंगे. अब order 7 का rule 1 to 8, if you see order 7 rule 1 to 8, you find what are the things to be kept in mind in writing of the plaint. But particulars of the plaint, contents of the plaint is written in. So आप एक एक चीज को ध्यान से लिखते जाएंगे. Contents of plaint, order 7, rule 1. Is this clear? Now you can see this also. You just now you go a little slow and you see everything. You see along with the class. Don't run fast. Let us be little particulars to be contained in the plaint. So order 7, rule 1. And then what are the things to be kept in mind while writing the plaint? So different things which are required to be kept in mind in writing the plaint. So that has been given in order 7, rule 1 to 8. Rule 1 to rule 8. So whenever you write plaint, you are required to keep in mind this whole. So we'll read all of them. Now this plaint is basically pleading. Plaintiff goes to the court, he gives a plaint. Defendant will come to the court and he will give written statement. Written statement is written in order 8, but we are not at that stage right now. अभी तो we have gone to court, we are filing the plaint. अभी हम न्यायालय पहुंचे और फिर plaint को फाइल कर रहे हैं. तो अभी plaint को कैसे लिखा जाएगा इसके बारे में जानेंगे आप. तो ऑर्डर 7 का रूल 1 to 8 आप देख लिए. अब आप जैसे ही plaint को लिखने जाएंगे तो plaint is basically pleading of the plaintiff. ऑर्डर 6 में आपने लिखा. What is pleading basically? Pleading क्या है? What is pleading? So you have written, pleading shall mean plaint or a written statement. Plaint is for plaintiff, written statement is for now defendant. Now rules of pleading which is required to be kept in the mind for this purpose at the outset. I am not going into great detail. Order 6, rule 1 and 2. So rule 2 basically says pleading to state material facts and not evidence. So we are not at the evidence stage. You are not required to write evidence in the plaint. No, you are required to write material facts only. Then in this context, as the civil suit is initiated by filing of the plaint, so order 4 rule 1 very clearly says every suit shall be instituted by presenting a plaint in duplicate to the court. Presenting a plaint in duplicate to the court. Is this clear? Is this all right? All right. All right. So order 4 rule 1 says, so plaint को लिखते वक्त हमने देखा order 7 rule 1, order 7 rule 1 to 8, and then I said order 6 rule 1 and rule 2 primarily. Basically order 7 and order 6 and order 4 are important here, I have told you. Every plaint shall comply with the rules contained in order 6 and 7. So जब भी plaint लिखेंगे तो order 6 and 7 को पढ़ेंगे. So far as they are applicable. In which case what is applicable, that is to be seen. So देखो law की भाषा बड़ी clear है. So far as they are applicable. It should not perturb you. It should not disturb you. You should take it very easily कि हाँ, as far as they are applicable. So if malice is there, malice has to be written. If condition precedent is there, it has to be seen. If it is money suit, money amount has to be mentioned. If it is immovable property related suit, immovable property description has to be given. So as far as they are applicable. Order 6 and 7, as far as they are applicable. Order 4, rule 1 very clearly says every plaint shall comply with the rules contained in order 6 and 7 so far as they are applicable. The plaint shall not be deemed to be duly instituted unless it complies with the requirements contained in sub rule 1 and 2 of rule 1 of order 4. So plaint को लिखने में whenever you write a plaint, you have to comply with order 6 and 7. You have to comply with order 6 and 7. हिंदी में बोले तो आपको जब भी वाद पत्र लिखना होगा तो आप आदेश संख्या 6 एवं 7 का पालन करेंगे. That is what I have said in English also. So you will comply with order 6 and order 7 whenever you write a plaint, and that is categorically stated in order 4 rule 1. It's basically in sub rule 3. Then it says court shall cause particulars of every suit to be entered in a book to be kept for the purpose and called the register of civil suits. Such entries shall be numbered in every year. I have told you, like FIR, you give FIR, so they will write FIR number and then year after that. So similarly here, suit number and year. If it is suit of this court, which is suit number 8 and year is 21, so they will write 821. So that is what is order 4. In writing of this plaint, there are many other things which are important, like order 2 is also relevant and order 1 is also relevant, which will come later on. Order 2 is basically on framing of suit and order 1 is regarding parties. So that is also relevant, we'll come to that little later. We are right now on the plaint. We will not mix everything, otherwise it will not be comprehensible easily. Is this clear? So we start with this point, that whenever we go to write a plaint, what is plaint? Who will draft the plaint? Aja, why do we want to draft the plaint? Why plaint? What is the object? What is the purpose? Why do we need plaint? The object, the purpose. Why? Why plaint? Why we started with plaint? Because see, every suit, now it says order 4 rule 1. The answer is there in order 4 rule 1. आप कहते हैं ना कैसे याद होगा मुझे चीजें कैसे याद होगी? I am emphasizing again and again. Order 4 rule 1 says every suit shall be instituted by presenting a plaint in duplicate to the court. Now, order 4 rule 1 says that plaint has to be presented. Without plaint, plaint has to be presented for initiation of civil suit. For initiation of civil suit. Even if we see section 26 of CPC, section 26 if you see, so section 26 says, if you see section 26, every suit shall be instituted by presentation of a plaint. So, section 26 also. Now, this is one reason. The another, if you do not file the plaint, how will you tell the court what is the cause of action? So, it is for communicating the cause of action, जो वाद का आधार होता है, cause of action, action on the basis of which cause is initiated, cause of action, the reason behind the suit. Cause of action is the reason behind the suit, the basis of the suit, the ground of the suit. On what basis? So you will say that I have right and my right is violated, so I want relief. Very simple. My property is there, somebody has dispossessed me, so I seek his removal from that place and I want him to be evicted from that place and I want restoration of my possession there. So suit is basically for communicating the cause of action to the court for relief. इसके बिना कैसे relief मिलेगा आपको? इसके बिना आपको relief नहीं मिल सकता. इसके बिना आपको relief नहीं मिल सकता. So civil suit starts with the plaint. Without plaint there can be no decree because there will be no cause of action, so no decree. And you want the decree of the civil suit, decree of the civil court. Decree is that final adjudication of the suit in a formal way. We'll read about that little later. हम section 2 की सारी चीजें पढ़ेंगे, but stage wise पढ़ेंगे. Then third, now when you write the plaint, you have to keep in mind that writing of the plaint is very, very important work, because whatever you ever in the plaint, whatever you write in the plaint, on the basis of that evidence has to be adduced. You cannot travel beyond the plaint. So that is why it is very important to draft the plaint very, very carefully. You have to draft the plaint very, very carefully. आप यदि carefully draft नहीं करेंगे, you cannot seek proper redressal of your grievances. And you cannot travel beyond the plaint propositions. You cannot adduce evidence beyond it. So that has to be taken care of. So why writing a plaint? I told you that, see, in other words, I can say that plaints are basically drafted in the lawyer's chamber. These are drafted in the chambers of lawyer to be considered in the chambers of court. So it is to be considered by the court, it is to be considered by the judge. So plaint drafting is very, very important, because if you do not disclose cause of action in the plaint, Order 7 Rule 11 says that it will be rejected. भाई आप यदि मुझे कॉज ऑफ एक्शन नहीं बताओगे, वो कॉमन सेंस से समझो, यदि आप मुझे कॉज ऑफ एक्शन नहीं बताओगे तो मैं आपको क्या रिलीफ दूंगा? यदि आप मुझे प्रश्न सही ढंग से नहीं बताएंगे तो मैं उत्तर नहीं दे पाऊंगा, मैं नहीं दे सकता उत्तर, फिर मुझे समझ में नहीं आएगा आप पूछ क्या रहे हो. So if I am not able to understand what is your question, how can I respond, how can I answer? Same is the situation of the court. If court does not understand the cause of action is the very heart and soul of the suit. So if the heart and soul is missing, how can we grant relief to you? हम कैसे आपको relief फिर grant कर पाएंगे? So plaint drafting is very important stage in civil procedure. And that is why it has to be taken care of. And it is initiation of suit, so that is why we have taken it at the beginning. Is this clear? Is this all right? Yes. So plaint drafting is very, very important. अब plaint को draft करने जा रहे हैं आप, तो rules of pleading important है, जैसे मैंने कहा. तो rules of pleadings क्या हैं in regard to this drafting of plaint? So you can write down them one by one. जैसे एक पहली बात लिखे, you write down. Somebody was saying that राइटिंग भी थोड़ा हो जाए तो अच्छा रहेगा. यस, राइटिंग होगा, बहुत सारे राइटिंग होंगे, तो आप लिख सकते हैं प्लीडिंग शुड स्टेट मटेरियल फैक्ट्स एंड नॉट एविडेंस. अभी एविडेंस नहीं देना, एविडेंस के स्टेज पर एविडेंस देना है. ओनली रिक्वायरमेंट इज दैट यू विल एनेक्स डॉक्यूमेंट्स विद द प्लेंट ऑन द बेसिस ऑफ विच यू आर सीकिंग द एक्शन. ऑर्डर 7 रूल 14 सेज, ऑर्डर 7 रूल 14, देखो हर चीज स्टेज पे, तो जैसे जैसे मैं बोलूंगा बेयर एक्ट देखते रहोगे, आपको समझ में आता है. बेयर एक्ट को बार बार देखना, बेयर एक्ट को बार बार देखना आपने. यू शुड नॉट बी इन ग्रेट हरी, यू शुड नॉट बी इन ग्रेट हरी. You are studying CPC, so please have patience, calm, and try to understand it slowly and distinctly. So Order 7 Rule 14 says production of document on which plaintiff sues or relies. Where a plaintiff sues or relies upon a document or relies upon a document in his possession or power in support of his claim, he shall enter such document in a list. बहुत सारे document का list बनाएंगे आप, and shall produce in the court when the plaint is presented by him. So it has to be presented by with the plaint, and shall at the same time deliver the document in a copy thereof to be filed with the plaint. Now देखो क्या लिखा है, he shall enter the document and shall produce it in the court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof, document भी उसकी copy भी, to be filed with the plaint. So be careful about this. Is this clear? Where any such document is not in possession or power of the plaintiff, where, what I said, just try to understand. Order 7 rule. So it says where a plaintiff sues upon a document or relies upon document in its possession or power in support of his claim, he shall enter such document in a list and shall produce it in a court when the plaint is presented by him. Is this all right? And shall at the same time deliver the document and a copy thereof to be filed with the plaint. Where any such document is not in his possession, उसके पास नहीं, और power, he shall wherever possible state in whose possession or power it is. जैसे उसके पास नहीं है उसकी कॉपी, तो वो बताएगा कि भाई कहाँ है, क्या है, किसके पास है, who is keeping this and is not giving me. Like now you might have gone to the court to claim your right in certain property. And this right may be claimed on the basis of sale deed or maybe on the basis of a partition deed or any other deed for that matter. And the deed is not available to you or not available with you. It is available with other partner or with other person. Then you will inform the court that this is not available with me, but my claim is based on this particular document, and the court can ask the other party to produce the document for proper information. A document which ought to be produced in court by the plaintiff when the plaint is presented or to be entered in list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not without the leave of court be received in evidence on his behalf at the hearing of the suit. So see, here is a problem. If you do not produce the plaint, if you do not produce the document in the beginning with the plaint, then not without the leave of court. Now it is court's authority. You have to seek permission of the court. Be received in evidence on his behalf. Nothing in this rule shall apply to document produced for cross-examination. That's a different matter. That is not for your right, but for cross-examination of other party or handed over to witness merely to refresh his memory. So in that case, this rule will not apply. You are not required to seek permission of the court. You can produce it. That's a different matter altogether. But try to understand the point very simply. Now, when you read CPC or any procedural law, you are basically now in many cases baffled by many rules written like this, but these are not so important. You just remember only this much, that whenever I present the plaint, I have to produce a document with the plaint. Document with the plaint. Order 7, Rule 14. Is this clear? And if you do not produce document with the plaint on the basis of which you are claiming the relief, and you do not inform the court that where it is, then it's your problem. Then in that case, if you want to produce it later on, then you have to seek permission. So you just translate these rules into your own language. It's very simple. It's very simple. Order 7, Rule 14 says production of document on the basis of which you are making a claim. If you do not have document, inform the court who has this. If you do not know who has this, then you inform the court that I am not aware. The court will ask the other party, court will inquire now into the matter. Is this all right? Is this all right? Then it further said, if you do not produce the document at the outset, then you do not have any liberty or privilege to present it later on, unless and until you take permission of the court. So that is clear. Order 7, Rule 14. So document भी आपको produce करना है. Is this clear? So I said plaint is basically drafted in the chamber of lawyers and it is to be considered by the chambers of the judges. So in that case your plaint must disclose cause of action. Your plaint must be beautifully written. Now at this stage it's very important to know how we should write the plaint. So we'll know little bit about writing of the plaint. It's a matter of practice. Now it's a matter of experience. If you now do more and more practice, you will learn it better and better. I have got a performa of plaint which I will share with you as well. A very simple one I have deliberately picked up. There are many performas which you might find on different forums also. अब देखो ये मैं परफॉर्मा डाल भी देता हूँ आपके इसमें ऐप में, आप भी देखेंगे. So whenever we write the plaint, see we start with this order 7 rule 1 and then we'll be discussing here and there certain questions. Order 7 rule 1 I have told you earlier also, but I will tell you again and I will go into little bit detail as well. The plaint shall contain the following particulars. So question is, what are the particulars? You frame the question and you write the answer. What are the particulars of a plaint? What are the particulars of the plaint? Just frame simple question and answer them very simply. अब रूल्स ऑफ प्लीडिंग तो थोड़ा मोड़ा पिछले दिन आपको बताया था मैंने, आपको याद है ना वो सब, बिफोर राइटिंग ऑफ द प्लेंट. नाउ भाई स्टेट मटेरियल फैक्ट्स एंड नॉट एविडेंस, यू रिमेंबर दैट फर्स्ट तो ये था. सेकंड, एवरी प्लेंट शैल कंटेन ए स्टेटमेंट इन कंसाइज फॉर्म. यू शुड नॉट राइट द स्टोरी देयर. आप वो भी क्वेश्चन बना सकते हैं, व्हाट आर द थिंग्स टू बी टेकन केयर ऑफ, उस पर भी लिख सकते हैं आप कुछ लाइनें. जैसे मैंने बताया, मटेरियल फैक्ट्स लिखो, स्टेटमेंट इन कंसाइज फॉर्म लिखो, divided into paragraphs. I have told you earlier also. Is this clear? मैं बार बार आपको बताऊंगा ये. Don't worry for this. Don't worry for this. मैं फिर इस पर आता हूं. I'll tell you time and again. Those who do not understand in one go, they will also understand it. Don't worry. But I start with this particulars of the plaint because that is the basic point, and then I'll discuss here and there the things. So सबसे पहले देखो, आप परफॉर्मा भी देख सकते हो प्लेंट का. इट इज गिवन इन अपेंडिक्स ए ऑफ सीपीसी. जनरली वी डू नॉट सी अपेंडिक्स. तो व्हाट आर द पर्टिकुलर्स ऑफ द प्लेंट? सो सबसे पहले आप ऑर्डर 7 रूल 1 को ही देखें. सो ऑर्डर 7 रूल 1 says the name of the court in which suit is brought. You should write this, in which suit is brought. Can you see this? Name of the court in which suit is brought. क्या क्या particulars हैं प्लेंट के? The name of court in which suit is brought. The name, description and place of residence of the plaintiff. वही order 7 rule 1. The name, description and place of residence of defendant. Is this clear? So far as they can be ascertained. अब देखो इसमें लिख दिया so far as they can be. अब just देखो ना, law is very smart, law is very clear. In plaintiff you have not written that because you are writing the plaint, so you know about yourself. अब कोई कहेगा इसमें लिखा, इसमें, just it is question of common sense. I may not have all information about defendant. You may not have all information about defendant. Obviously in this virtual world where you are entering into contract with many people on virtual platform, so you may not be knowing exactly name, description and place of residence of the defendant so far as they can be ascertained. So 3 things आपको यही लिखना है. So यदि पूछे what are the particulars of plaint, order 7 rule 1, and you can write down court. मैं briefly लिखूंगा. Then you said plaintiff, then you said defendant, all right. Then D, if it is minor or person of unsound mind, a statement, minor or unsound. So this is what is particular of plaint, minor or unsound mind, statement to that effect. हम लोग हर चीज को समझेंगे, but now very coolly, calmly. The facts constituting the cause of action. This is very, very important. I said cause of action is the very heart and the soul of plaint. If you are not able to disclose cause of action, if you do not communicate cause of action, then how will you get the relief, tell me? If there is no cause of action, then how will you get the relief from the court? So, the fact constituting the cause of action and when it arose. Fact and time. Fact and time. Is this clear? Court is 1, plaintiff is 2, defendant is 3, minor or unsound is 4, cause of action is 5. Is this clear? Is this clear? 5 things you have written. Now 6. 6 को देखो. 6 में क्या है? So 6 is the fact showing the court that the court had jurisdiction. Fact showing that court had jurisdiction. So 6 you will show court's jurisdiction. 7, relief which the plaintiff claims, the relief which plaintiff claims. So briefly, jurisdiction and relief. 8. Where the plaintiff is allowed a set off or relinquished a portion of his claim, the amount so allowed or relinquished. So, a relinquishment where you have waived off, relinquished, chhod dena. You do not want to claim. See, plaintiff is master of the suit. If you have claim of 1,000 rupees, you may not claim 1,000 rupees to be within the jurisdiction of the court. Suppose the court of first instance at local level has jurisdiction of 900 rupees. So what you will do, you will claim only 900 rupees because you know that if I claim 1,000 rupees, I will go to higher court and it will now result into more expenses, more trouble for me. So it is always better that I should claim in this court. So you will relinquish 100 rupees claim and you will claim only 900 rupees. So that is always your discretion because this is your claim. So you can do it. आप ऐसा कर सकते हो. Then it says set off or relinquish. So relinquishment or set off. Set off means setting off of mutual debts. Set off means setting off of mutual debts. I have taken 1,000 rupees debt from you and you have taken 500 rupees from me. So you can claim 500 rupees from me only because 500 rupees will be set off. So if you have set off any claim, then you will mention also that. And a statement of the value of subject matter of the suit for the purpose of jurisdiction and of the court fees as far as the case admits. A statement of the value of subject matter. For pecuniary jurisdiction, it is important for the purpose of jurisdiction and of court fees, and also for court fees because court fee will depend upon the valuation of the suit. So this is your duty, this is the duty of plaintiff's counsel to value the suit and to submit proper court fees. For that, valuation is necessary. You will value your suit in that sense. Is this clear? So these are the 8 things, rather 9 things. 9 things. Valuation of suit claim. So क्या क्या हो गया आप ध्यान से समझ लो. कुछ नहीं है, बहुत सिंपल है. First I said court, then I said plaintiff, then defendant, then minor unsound, then cause of action, then jurisdiction, then relief, then set off, then value. So you only just keep in mind the words. If you want to be now better clear on this point, you just keep in mind the words written here. The words written here. You should not go into great detail, you just keep in mind the words which I just mentioned before you. It's very, very simple. I started with court, अभी दिखाता हूँ आपको. Then I said plaintiff, then I said defendant, then I said minor or unsound. So 1, 2, 3, 4. Is this clear? Then I said this cause of action. Five. Then jurisdiction. 6. Then relief. 7. Then you said this set off or a relinquishment. If you keep this in point form, it will be always better for you to memorize. Value of subject matter, so suit valuation. We'll read about these facts, these things that if it is not done, then what will be its effect, impact. Is this clear? So this is what has to be taken care of. 9 things at the outset. अब कोई भी आप प्लेंट को देखेंगे तो उसमें आपको ये 9 बातें मिलेंगी. कोई भी प्लेंट को देखो. Is this clear? कोई भी प्लेंट में बहुत सिंपल सा आपको प्लेंट का एक परफॉर्मा ऐप में देता हूं, आप उसको ना देखिएगा और बताइएगा कि आपको ये चीजें क्लियर है या नहीं है। पहले मैं बता देता हूं, व्हेन आई विल टेक ब्रेक यू विल सी, मैं यहां क्लास में आपको भी बताता हूं, डोंट वरी। इस एक पेज को ऐप में डाल दो, फर्स्ट है वो सेकंड है, और मेरे को पेज दे दीजिए। इज दिस क्लियर? सो मैं आपके ऐप में ये डाल रहा हूं, आप अभी मैं बताऊंगा आपको, उसके बाद आप देखेंगे। भी कुछ भी नहीं है, बहुत सिंपल है, इट्स वेरी वेरी सिंपल थिंग। बट बिफोर डूइंग दैट लेट मी गो इनटू ऑर्डर 7 रूल 1 little bit in necessary details, not all details, but I will read a little bit further. See, order 7 rule 2 money suits, देख रहे हैं आप, मनी सूट्स। तो मनी सूट्स जब भी आप फाइल करेंगे तो विल यू नॉट मेंशन द अमाउंट? इफ यू डू नॉट मेंशन द अमाउंट, हाउ द कोर्ट विल नो एग्जैक्टली? सो आई सेड मनी सूट मैंने आपको बताया था शायद, purely a suit for recovery of money is known as A suit. Other suits are known as B suit, and other suits are known as A suits. So money suit is basically purely a suit for recovery, etc. This is suit B. And other suits, this is how this is named, money suit. So if this is a money suit where the plaintiff seeks recovery of money, the plaintiff shall state the precise amount claimed. Is this clear? Where the plaintiff sues for mean profit or for an amount which will be found due to him on taking unsettled accounts, or for movables in the possession of defendant, or for the debts of which the value he cannot after the exercise of reasonable diligence estimate, the plaintiff shall state approximately the amount or value sued for. Is this clear? In a money suit, as a general rule, where the plaintiff seeks for recovery of a specific amount, the precise amount must be stated. So, money suit में precise amount. This is general. I know I have given you 10,000 rupees, so I will claim 10,000 rupees, that's all. If there is any interest, etc., I will claim along with that. So their exact quantification must be stated. Amount claim must not be any uncertain amount or uncertain amount. The exact amount must be stated. Now, अब आप precise amount लिखना है। जैसे आपका, now suppose on basic calculation I have come to know that my claim is 9,549 rupees. So I will write 9,549 rupees and not 10,000 approximately. So this is what is, clarity is required. This is not. This is permitted. This is permitted. Precise amount 9,549. So हम exactly वो claim करेंगे 9,549 rupees. That is what is being said. When plaintiff sues for mean profit is profit in the intervening period where it was in your possession which was not lawful and you obtained. Like now, your lease has expired on a particular date. Lease समझते हैं ना, rent जैसे rent पे property देते हैं, आप लोग समझ ये lease है. तो lease has expired and now you are keeping it and you are using it further. So will you not give me money or rent for that particular period? Or suppose you obtained some benefit out of that property, extra benefit which I would have obtained by keeping the property in possession. So will you not give me that extra profit? So that is what is called mean profit. That extra amount I will explain to you again when we will reach to that stage, when I talk about the relief in the suit. I am not into that. I am into writing up the plaint right now. Just you will have to understand, you have to be stepwise go further. We are not discussing relief right now. We are not discussing judgment right now. When we will give judgment, then we will discuss the relief granted. Then we will discuss the interest, how it is granted. we'll discuss the mean profit, how it is granted, but not right now exactly, but you must understand mean profit. जैसे आप पढ़ोगे ना, mean profit is written in section 2. I'm not teaching you right now mean profit, I'll come to that again. But wherever any word comes in question or comes in discussion, it is always better to refer to that particular. See, mean profit is defined in section 212. What it says? Mean profit means profit. Now, those profit which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest, but shall not include profit due to improvement. So, very simple. If the property is in your wrongful possession and you have obtained some benefit that is there, or which you might have obtained, which you did not obtain, but you might have obtained if you would have applied your mind with reasonable diligence. आपने प्रॉपर्टी को रेंट पे नहीं लगाया, लगा सकते थे, सबलेट कर सकते थे, बट आपने नहीं किया. It was permitted in that particular case, but you did not do it. So I will claim even that because that is my loss. But not earning due to improvements made by you, because I am not entitled to any earning from improvement made by you. The law is common sense. If you have made the improvements, if you have done something extra, you are entitled to that. But you are keeping my property in wrongful possession, so am I not entitled to the benefit? The answer is yes. So that is what is mean profit. Is this clear? So mean profit is profit now earned or may have been earned, both, which you earned basically and which you might have earned, both are included. So if it is mean profit, it says, or for an account which is unsettled or for movable where the value cannot be estimated by the approximate amount, because it is not exactly now known how much profit you earned. Unsettled account, it is not exactly known. So in that case, approximate amount. The law is so careful, so commonsensical, then approximate amount, because it is unsettled. Unsettled account. Mean profit which is not exactly known. Mean profit. S is silent in reading. Mean profit. That is why we say mean profit. MESNE. I hope everybody has Bare Act. You must develop this habit of reading Bare Act. Mean profit. Unsettled account. Mean profit. So it is unsettled. So that is why approximate. Is this clear? Now then it says, where the subject matter of suit is immovable property. अब देखिए सूट का सब्जेक्ट मैटर क्या है? इमूवेबल प्रॉपर्टी. सो विल यू नॉट मेंशन दैट वेयर इज दिस प्रॉपर्टी एग्जैक्टली? सो यू ऑन दिस पॉइंट यू कैन जस्ट राइट डाउन ऑर्डर 7 रूल 3. ऑर्डर 7 रूल 3. ये ऑर्डर 7 रूल 2 था. सी now those people who say that I can't remember, they will remember everything. Order 7 rule 1 is particulars of Plaint. Order 7 rule 2 is money suit. Order 7 rule 3 is immovable property. So you can pick one word and you can memorize important things. Though it is not necessary always to memorize, but you can keep these things in mind very simply. So order 7 rule 3. Order 7 rule 3. Very simple. Here you can keep one word in mind, immovable property. Where subject matter is immovable property. Description of property which is sufficient for identification. Plaint should mention description of property for identification. For identification. It is the plaint. If in the plaint there is violation of Order 7 Rule 3, then the plaint is liable to be rejected. Now, plaint is liable to be rejected. Sir, we are not discussing that. Tiwari ji, please stop. I have told you not to raise question in between. We are not discussing rule 2A. This tendency is not good, I have told you. Which I am not doing, you should not. And there is question answer session, Amit Tiwari ji. So you wait for your turn if you are very anxious to know. Rule 2 is not relevant. We are not discussing commercial dispute here. आपको नहीं समझ में आएगी बात जब तक आप परेशान नहीं करेंगे ना हमें और अपने आप को भी, तब तक आप परेशान. ये स्पेशल अमेंडमेंट है. आर वी डिस्कसिंग दिस राइट नाउ? नो, वी आर डिस्कसिंग हाउ प्लेंट इज टू बी रिटन. हम एक जनरल चर्चा कर रहे हैं. अभी पहले जनरल समझेंगे, स्पेशल पर बाद में आएंगे. ये सब नहीं होता है. और आप अपने से भी पढ़ सकते हो. इसमें कुछ ऐसी बात मेरे ख्याल से नहीं लिखी है. हालांकि आप मेरा समय नष्ट करने में इंटरेस्टेड हैं तो कर सकते हैं, आपकी मर्जी है. मेरे को एक फ्लो चाहिए, मेरे को कोई इंटरवेंशन नहीं चाहिए इन बिटवीन. आप यदि इंटरवेंशन करेंगे, मैं बार बार आपको आगाह कर रहा हूं, तो मेरा फ्लो टूटता है. आप ज्यादा स्मार्ट हैं तो आप ही पढ़ लो, मेरे से मत पढ़ो. फिर मुझे लगता है कि मैं स्मार्ट हूं. मैंने बैरक लिखा है, मैं और भी बहुत सारे काम कर रहा हूं और मैं स्मार्टली काम कर रहा हूं. मैंने प्लेंट क्यों लिया पहले पढ़ाने के लिए? देयर इज अ रीजन बिहाइंड दैट, एंड द रीजन इज दैट वी स्टार्ट सिविल सूट विद द राइटिंग ऑफ प्लेंट. मैं पहले आपको प्लेंट लिखना सिखाऊंगा और मेरा दावा है कि इफ यू अटेंड माई क्लास सीरियसली यू विल लर्न हाउ टू राइट ए ब्यूटिफुल प्लेंट विच लॉयर्स मे टेक 10 years टू लर्न. आई मस्ट टेल यू. रूल 2A में ऐसा क्या लिखा है जो मैं आपको पढ़ के बताऊंगा? जरा बताना मुझे ही पढ़ के. एवरीथिंग यू शुड नॉट आस्क टू योर टीचर्स, यू रीड योरसेल्फ आल्सो इफ यू आर इंटरेस्टेड. हर लाइन पढ़ के टीचर थोड़ी बताएगा आपको. ये अननेसेसरी का दिमाग लगाना कि सर ने एक चीज छोड़ दिया और सर ने जानबूझ के छोड़ा है, ये ना बहुत गंदी टेंडेंसी है. मैं बार बार कह रहा हूं, आप मेरे को क्लास में परेशान नहीं करेंगे, नहीं तो मेरे को ना फ्लो नहीं बनेगा. आपको लगता होगा कि पढ़ाना ऐसे ही हो जाता है, बट वो आप ऐसी ही पढ़ाई फिर पढ़ेंगे चालू टाइप. आपको नहीं समझ में आ रहा है कि मैं आपको किस लेवल पे ले जाना चाह रहा हूं. यू वांट टू डिस्टर्ब मी, दैट्स योर चॉइस, आई कांट हेल्प इट. इफ एनीवन डिस्टर्ब्स द होल विल बी डिस्टर्ब्ड, द होल क्लास विल बी डिस्टर्ब्ड. रूल 2A में कुछ नहीं. ये वाला टेंडेंसी ना बहुत गलत टेंडेंसी. आप कुछ भी लिखते रहते हो बीच में. रूल 2A में ऐसा क्या लिखा है मुझे कोई भी बता दे जो नहीं समझ में आता हो. अब देखो लिखना शुरू हो गया. नहीं तिवारी जी, आपकी फर्स्ट है या लास्ट है? आपकी फर्स्ट है लास्ट, आपको रूल्स पता होने चाहिए गेम के. आप पहले दूसरों को वॉच करो ना. तो ऐसे आप हर चीज पूछते मेरे से, एक ही क्यों पूछा? पूछो बाय एक्ट 4/2016 सेक्शन 16 एंड शेड्यूल 4C विद रेट्रोस्पेक्टिव फैक्ट फ्रॉम 23/10/2015 क्या है ये भी बताओ. बस यही सब मैं क्लास निकाल दूंगा, मैं जैसे निकालते रहे लोग पूरे विश्व में. रिदम को तोड़ना चाहते हैं. पता नहीं, मुझे नहीं समझ में आता कि आप लोगों को बताया नहीं जाता कि आपको बीच में सवाल, आपको बताया नहीं किसी ने एडमिशन के वक्त के बीच में सवाल नहीं करना है. क्वेश्चन आंसर सेशन होता है एक, आप वहां सवाल करेंगे यदि आपको कोई सवाल होगा तो. लोग रिदम को तोड़ता रहता है मेरा. चलो आई टेक फ्यू मिनट्स ब्रेक, देन आई विल बिगिन. रिदम में क्लास चलनी चाहिए, बिल्कुल फ्लो में. मजा आता है उसमें. यू लर्न इट एंड यू लव इट. चलिए, ऐसे भी 50 मिनट से ज्यादा आप रिदम में नहीं चल सकते हो. आपने अच्छा ही किया, रिदम तोड़ दिया. चलो 2-3 मिनट के लिए रुक जाते हैं. जस्ट होल्ड फॉर 2-3 मिनट्स. 5 मिनट के लिए रुकते हैं. 6:05, 6:10 पे शुरू करेंगे, ठीक है? So I was talking about Order 7 Rule 3, where the subject matter of suit is immovable property. I was saying Plaint should mention description of property for uh, Plaint should mention description of property for proper identification. You know generally that the property is identified on the basis of khata number, khasra number, tawji number. Various places have various kind of nomenclatures. We are not required to go into that, but you know basically these things that a property is identified on the basis of its location, and how will you identify location on the basis of there is word also called thana and khata and khasra and tawji. So there are certain numbers on the basis of which you can identify plot number. भाई इस प्रॉपर्टी का प्लॉट नंबर क्या है, ये किस खाता किस प्लॉट में है, खाता खेसरा प्लॉट. So different kind of identification methods are there as far as identification of property is concerned. So if you do not give exact details of property, if you do not mention exactly where the property is situated, now neither I can fix the jurisdiction nor I can know about exact valuation, because different places will have different valuations of property also. No? But see, these are rules of procedure. Now the rules of procedure are basically handmade to justice. So if there is no anomaly and as such which does not go to the root of the matter, and rather it is a kind of clerical and arithmetical or any kind of trivial error, then we are not going to take it very seriously. We will try to correct it. And see, there are various provisions in CPC which is meant for this purpose. You can correct this. I think one of the provision is section 152 in CPC, which talks of removal of certain errors. Various procedural laws have this kind of, I think even in CRPC there are certain provisions like 362. So 152, amendment of judgment, decree or order. Clerical or arithmetical mistakes in judgment, decree or orders arising therein from any accidental slip or omission may at any time be corrected by the court, either of its own motion, any time, even after the judgment is given. We'll come to these things again and again. So if you somehow miss to give correct identification of property in the sense that you wanted to write something and you happen to write something, so in that case law is not going to punish you severely. No? Oh, so that kind of thing can be excused and permitted. So you can write down properly, Plaint shall contain a description of property sufficient to identify it, spacing the boundaries or number in a record of settlement or survey. So boundaries, जिसको आप चौहद्दी कहते हैं हिंदी में, आप boundaries बताते हैं ना भाई, who is there in the south, who is there in the north, who is there in the west, who is there in the east. You generally write all these things. And what is the measurement of property, how wide and how depth, whatever. I am not going into exact terminology which we use there. So you must understand that we are not basically laying down very hard and fast rule, but if you do not identify the property at all, the plaint is liable to be rejected because you are not giving me the exact details of the property. But if there is any accidental error or slip, if there is any chance of amendment, let us do it. If there is no chance like that, what can we do? What can we do? If you do not identify property at all, what can we do? If you do not identify the property at all, what we can do? But if there is an accidental error or slip, then we can amend it, we can correct it. Section 152, I told you, there is a provision. Now then, let us go further. Order 7, Rule 4. Just have a glance because the representative suit has to be read separately. Order 1, Rule 8, I hope. When the plaintiff sues in a representative character, the plaintiff shall show not only that he has an actual existing interest, but that he has taken the steps necessary to enable him to institute a suit. Taken the steps necessary. Taken the steps necessary is given there in Order 1, Rule 8 when you file a representative suit. That we are not discussing right now. Is this clear? Again and I am mentioning what we are discussing right now. तब तो हम representative suit पढ़ने लगेंगे, which is a separate topic altogether. There are many things which are related to one another, but we can discuss one thing at a time very clearly. Otherwise, if we mix 10 things, we will understand nothing. So that is not the idea here, and that is why there is restriction and regulation on your this inquisitiveness in between. Inquisitiveness towards the end is welcome. So when plaintiff suit, so representative suit. And I said read with which order and rule? Order 1, Rule 8. मैं देख लेता हूँ, just let me check also whether I'm saying it correctly or not, because you should not be overconfident. One person may sue or defend on behalf of all in same interest. Yes, Order 1, Rule 8, because that is related to parties. Parties. Order 1, Rule 8, that is related to party. So representative is also a party to the suit. So representative suit, if representative is filing a suit on our behalf, then this is a representative suit. Is this all right? Order 1, Rule 8, that will have to be mentioned. Defendant's interest and liability to be shown. If I am claiming some amount against you, will I show your liability or not? Tell me that you are liable to pay me this much money. So whether the plaint averment should contain all these details or not? The answer is obviously yes. What it says, plaintiff shall show that the defendant is or claims to be interested in the subject matter. Now look, suppose I have filed a suit for recovery, or I have filed a suit for this eviction. In suit for eviction, I am saying that this is my property, suit property belongs to me, and I am the title holder of the property. I am the de jure de facto owner of the property, and he has entered into my property without my permission, and he is a trespasser. Now defendant says, no, I am also claimant in the property. So all these things have to be mentioned. I will mention my interest and defendant will mention his interest. These are all commonsensical. Don't go into nitty-gritty. So it's very simple, general. It says plaintiff shall show that the defendant is or claims to be interested in subject matter, that he is arguing this which is baseless. He is also claiming the title over the property which he does not have. His father has gifted me property, but he says that as successor I am the owner of the property, which he is not, because his father has already gifted me this property. So I will show the gift deed, and he will show that he is successor of the father and it is his property because father has died and so he got it in succession. So that has to be basically averred in the plaint, that he is liable to be called upon to answer the plaintiff's demand. Plaintiff says it's gift deed in my favor, so plaintiff will show that. And obviously Order 7, Rule 14 says that you annex the document also, so you will show that the gift deed is here in my name, it is properly registered. It has been entered into register of property there in registry office. So all things have to be shown basically carefully. So Order 7, Rule 5. Defendants in interest and liability to be shown. Is this clear? Grounds of exemption from limitation. But simple बातें हैं. Grounds of exemption from limitation. So write down here, if you claim exemption from limitation, If plaintiff claims exemption from limitation, if plaintiff claims exemption from limitation, then it has to be shown. If plaintiff claims exemption from limitation, then it has to be averred in the plaint. Like now, if it is some legal disability which is mentioned there in limitation law, then he will mention that if the court was closed on the last day of the limitation and due to which he could not file the case, and he has all right to file the case when the court is open, so he will mention this. Whatever it is there, I am just taking a raw example, whatever is there, on whatever basis you claim exemption from limitation, so you will show that the ground of limitation is there. And that is why you must understand, before proper understanding of CPC, you have to have little bit idea of limitation law, little bit idea of specific relief, little bit idea of contract law, little bit idea of property law. So what we will do, if you do not have any idea of anything, wherever in discussion it will come, we will refer to the relevant point and will try to understand as far as possible within the scope of this class. Specific relief, limitation law, contract law, TPA, registration law, all these are different territories of law. But they may come in picture sometime here and there, because no law can be said to be mutually exclusive and disjunctive. There are necessary correlation and interrelation between different subjects of law. So they will enter into each other's territory. There will be many unions. So this is going to happen, many intersections will be there. So we'll take care of that fact, but here it's very simple. Ground of exemption of limitation has to be mentioned. अब आप इस बात को समझे, कभी हम प्लेंट को लिखने जा रहे हैं, हम बात यहां कर रहे हैं, लिमिटेशन लॉ की बात नहीं कर रहे हैं, but that has to be taken care of. Provided that the court may permit the plaintiff to claim exemption from law of limitation on any ground not set out in the plaint, if such ground is not inconsistent with the ground set out in the plaint. This is amended provision. This was added in year 1976. So proviso empowers the court. Proviso empowers the court. It gives additional power to the court to permit the plaintiff to rely on, you write down, to permit the plaintiff to rely on new ground, to rely on new ground, to rely on new ground, new ground for exemption, so long as it is not inconsistent with, so long as it is not inconsistent with the ground mentioned in the plaint. So long as it is not inconsistent with the ground mentioned in the plaint. This is clear? देखो मीनिंग में भी यहां तुम्हारे इसमें बेयर एक्ट में लिखा हुआ है. इज दिस क्लियर? Relief to be specifically stated, very important. Write down on this point also. Relief to be specifically stated. On this point you write down further. Wherever plaintiff claims either relief simply or in alternative, either relief simply or in alternative. Many times you ask for relief alternatively, like in a specific relief act. You claim either for a specific performance of contract or you may claim some kind of damages. If he does not perform the contract, you pay me the damages. So you claim relief in alternative. I want a specific performance of contract, but if it is not possible or not granted by the court, if it is not allowed, then another relief, and that the relief is of damages. So that is permissible, that is justified. So either relief simply or in alternative. Is this clear? These are the rules of writing of plaint. Nothing much. It says, if I read rule 7, it says, every plaint shall state specifically the relief which the plaintiff claims either simply or in alternative. And it shall not be necessary to ask for general or other relief which may always be given as the court may think, just to the same extent as if it had been asked for. And the same rule shall apply to any relief claimed by the defendant. Now, same rule applies to the defendant also when he claims relief in written statement. Is this clear? Relief founded on separate grounds. This is the last rule in this particular subplaint, where the plaintiff seeks relief in respect of several distinct claims or causes of action. बहुत सारे claims है, बहुत सारे causes of action है. Founded upon separate and distinct grounds, they shall be stated as far as may be separately and distinctively. Like I said, that there is a car accident, suppose. In car accident, the car has been damaged, and the person who was sitting in the car, he has been injured. So there is one injury to the body and there is another damage to the property. So these are distinct causes of action. Causes of action are different because you will plead different facts. I'll tell you about causes of action also when I will go to essentials of suit. So causes of action are basically material facts on the basis of which you claim relief. So when you seek relief for damage to the property, that is car, and when you seek relief for personal injury, these relief are exactly separate, and these reliefs are founded on different causes of action. So will you claim them separately or not? The answer is obviously yes. So rule 8, when you read it, it says where the plaintiff seeks relief in respect of several distinct claims or causes of action, founded upon separate and distinct grounds, they shall be stated as far as may be separately and distinctly. उनको अलग अलग और distinctly plead करना है. This is perfect. This is perfect. Is this all right? The damage to the car is one cause of action, that is damage to the property, and the injury to your body, that is different cause of action. आप देखो ना भाई, body को injury, it's a different fact situation, and damage to car is different fact situation. So they are different causes of action. Are you getting my point? This should be clear to your mind. I'll discuss this again. Causes of action. So you should understand. I hope you have little bit idea of Order 7, Rule 1 to 8. Order 7, Rule 1 to 8. Is this clear? एक केस में क्लैरिफिकेशन भी, एक लिमिटेशन पर, संतलाल महतो वर्सेस कमला प्रसाद, दिस इज 1951 डिसीजन. देखो कोर्ट की भी ड्यूटी है लिमिटेशन में. संतलाल महतो, मैंने पहले भी क्लास में शायद पढ़ाया होगा तो मैंने लिखा है, संतलाल महतो वर्सेस कमला प्रसाद. we have to bring all relevant points also when we discuss these things. So you just write down. ये लोग भाई मानेंगे नहीं। अब देखिए ये अपनी परिभाषा लिख रहे हैं दिव्यांश महाजन, सेम कॉज ऑफ एक्शन, जब कितनी अच्छे से बता दिया कि भाई प्रॉपर्टी का डैमेज और बॉडी का इंजरी सेम कॉज ऑफ एक्शन, सेम फैक्ट्स प्रूव कर दोगे। यार तुम क्या पढ़ रहे हो, क्या सुन रहे हो, मुझे तो समझ में ही नहीं आ रहा। I can't accept this. I have said so categorically. It is unnecessarily confusing even others. डैमेज टू कार में एंड इंजरी टू प्रॉपर्टी में आप सेम फैक्ट्स प्रूव करेंगे। हाउ कैन इट बी सेम कॉज ऑफ एक्शन? एंड आई हैव सेड इट ट्वाइस थ्राइस, सो यू लिसन टू मी, डोंट कंफ्यूज अदर्स ऑल्सो। Please stop this, I am telling you. This cannot be continued in this class. I will not allow this to happen. So, देखो बहुत सारे विद्वान बैठे हैं, you explain this again and again, I will be explaining this again. You don't hear me, you don't listen to me. Why are you in hurry? मैं जब एक बार बता दिया, ऐसे तो आप 50 बार you explain with different examples. अरे तुम हमको सिखाएगा कैसे पढ़ाना है मुझे? मैं बार बार कह रहा हूं, you behave yourself. I am asking you very simple question, damage to car and injury to person एक ही चीज है। आपके कहने से सेम कॉज ऑफ एक्शन हो गया। आई शुड एक्सप्लेन इट बाय 10 एग्जाम्पल्स। See, this is online class, in this more discipline is required. What happens by this, writing these things, what happens, others have a sense of uncertainty in the class. That there is something which I did not appreciate and this boy has problem and he has written this. Though you have written unnecessary. So, see, I am a truthful teacher, I would explain everything and I would accept every fault of mine. But unnecessary explaining and writing and suggestion to a teacher, it's uncalled for. It is indisciplinary behavior according to me. You have a question answer time, if you do not understand, 7:45 you raise questions. Whatever I have taught, I will answer every question of it. But you can't write in between. This is totally restricted. नहीं, आपको पूछने का अधिकार है, आपके लिए 7:45। क्या आपको इतनी बात समझ में नहीं आती? विद ड्यू रिस्पेक्ट यू डू ऑल इनडिसिप्लिनरी बिहेवियर। आई हैव टोल्ड यू क्वेश्चन आंसर टाइम इज 7:45। डू यू नॉट अंडरस्टैंड दिस? यू डोंट राइट विद ड्यू रिस्पेक्ट, देयर इज नो रिस्पेक्ट एट ऑल, दिस इज इनडिसिप्लिन। आप बहुत बड़े काबिल होंगे, मुझे उससे मतलब नहीं है। आई हैव टू परफॉर्म माई पार्ट। Again and again writing in the group and raising question, it is uncalled for. I did not understand that why I asked question. कोई भी लिख सकता है ऐसे ही। Anybody can say this. This is a bald statement. Anybody can say I did not understand so I wrote it. देखो भाई, ऐसे जब पब्लिक लाइफ जीते हैं ना, बहुत सारे बिहेवियर हैं जो आपको करना पड़ेगा। ये इंडिविजुअल ट्यूशन सेंटर नहीं खोला हमने, ये क्लास है। You have a question answer session and you have been told everything at the time of admission. Question answer session में आप क्वेश्चन पूछेंगे, इस तरह से बीच में unnecessary question लिख करके with due respect, no respect. I don't take it that way. अभी अभी मैंने कहा no question, I did not understand. What is you did not understand? Damage to car and injury to person you did not understand. Injury to person में तुम क्या दिखाओगे? बॉडी को इंजरी हुई। और डैमेज टू कार में क्या दिखाओगे? प्रॉपर्टी को। फैक्ट सेम हो गए। I did not understand. Anybody can write I did not understand. I'll be helpless. This is how a class can be spoiled. I have said very, very clearly that see, I am here to help you, but not in your terms. Class मैं चलाऊंगा, it's my discipline, it's my rule which will prevail. Be very clear on this point. I respect all of you, but you cannot dictate me. Give me more examples. Do this, do that. I am not your servant. With due respect, you are my servant. This is what you have written. भाई मैं ना ऐसे क्लास नहीं ले पाऊंगा. You must behave. देखो तुम लोग ना बार बार यही करोगे, मुझे पता है. This is how class is spoiled. I must tell you. इसमें कुछ भी समझने वाला मैंने आपको बता दिया, कुछ भी समझने वाला नहीं. You are unnecessary asking this. ये लिख दिए. But sir, don't both the relief arise from the same cause of action, that is relief for car accident. ये क्या, ये अपने से आपने फैक्ट बना दिया. अभी आपको कॉज ऑफ एक्शन तो मैं पढ़ा नहीं रहा हूं, थोड़ा मैं और पढ़ाऊंगा जब रिजेक्शन ऑफ प्लेंट बताऊंगा. ऑर्डर 7 रूल 11 में पहला ग्राउंड यही है. मैं अभी कॉज ऑफ एक्शन की चर्चा तो कर नहीं रहा. आप इतने कंफ्यूज हैं तो आप कुछ नहीं कर पाएंगे लाइफ में. आप ज्यादा कंफ्यूजन मत क्रिएट करो. बी क्लियर, बी सिंपल. किसी ने मेरे कार को चोट पहुंचाई और किसी ने मेरे शरीर को चोट पहुंचाई. इज इट नॉट सेम कॉज ऑफ एक्शन? अब आप कुछ भी लिख दो. अरे कैसे हो जाएगा? दोनों के फैक्ट्स अलग अलग है. इंजरी बॉडी को ही तो मैं वो दिखाऊंगा, इंजरी बॉडी को ही, और इंजरी यदि कार को ही तो वो दिखाऊंगा. दोनों के फैक्ट्स बिल्कुल डिफरेंट है. एनीबडी कैन अंडरस्टैंड दिस. बट सर आई हैव ए प्रॉब्लम. विद ड्यू रिस्पेक्ट, आई डिड नॉट अंडरस्टैंड दिस. तब तो कोई भी, एनीबडी कैन राइट एनीथिंग. दिस शुड बी अंडरस्टूड इन फेयर टर्म्स. इफ यू वांट दिस क्लास टू प्रोड्यूस द बेस्ट, you must behave. This is not the way. तो anybody will say I did not understand. मैं क्या कर लूंगा फिर? मैं तो यही करता रह जाऊंगा, मैं पढ़ा ही नहीं पाऊंगा. This is what many people did in SRA class. I have taken a lesson. No. This is not going to be permitted. No, please, no. 7:45 is question answer session. You ask question then. You have no right to ask in between, sir. Please, sorry. Then this class cannot be run like this. And if you disturb me a lot, I will leave the class. I cannot take class like this. I want rhythm to be built. So anybody will write now there are 400 people in class. Anybody will write, I did not understand, sir. Every time they will write, I did not understand. And many people may not be concentrating. They will never understand. I have seen it in offline classes also. I am teaching in the class, somebody is busy on the phone. Even in offline. Why they join the class, I don't know. Why they waste their time and money if you are not serious enough. No, this cannot be permitted. Sir, I am extremely sorry, this cannot be permitted. I will not ask again. Did you not understand this before? Nishant Kumar, Divyans Mahajan, I have written it just before. ये लोग नहीं चाहते हैं क्लास अच्छे से. Some people are not if I am disturbed time and again, I will not take class. You must behave. पहले देखो डिसिप्लिन को मेंटेन करना बहुत जरूरी है क्लास में. आई वॉन्ट दिस क्लास टू बी वेरी डिसिप्लिन. आई विल आंसर ऑल योर क्वेरी. अभी तो तुम्हें सवाल पूछना भी सिखाऊंगा मैं. तुम ज्यादा देखो, कहते हैं ना एम्प्टी वेसल साउंड मच. आई एम योर गार्जियन, लेट मी डू, लेट मी स्पीक. हम भी ऐसे ही थे एक दिन, मैं तुम्हें बता दूं. मुझे भी भ्रम था, मैं बहुत तेज विद्यार्थी हूं and I can grill the teacher. Just writing 2 lines in the group doesn't make you intelligent, I must tell you. If you have this belief, change your idea. You are wasting my energy, I tell you. भाई तुम लोग कल से ना क्लास में आ जाओ सीरियसली ना. मैं तभी पढ़ाऊंगा, मैं नहीं पढ़ाऊंगा ऐसे. I can't teach like this ना. ये ना क्लास को लोग डिस्टर्ब करेंगे और क्लास हमेशा ऐसे ही डिस्टर्ब होती होगी. आई हैव गिवन यू ऑल फ्रीडम टू आस्क मी टुवर्ड्स द एंड. यहां टीचर आपका क्वेरी सॉल्व करने के लिए लगा हुआ है. पहले तो क्वेरी हो नहीं, क्वेरी हो तो विल सॉल्व ऑल क्वेरीज. एंड इफ वी डू नॉट सॉल्व देन यू टेल मी. बट जस्ट डोंट डिस्टर्ब द क्लास. नो, दिस इज नॉट परमिटेड. मैं मैकेनिकल क्लास नहीं ले सकता. मुझे डिसिप्लिन मेंटेन करना है. I will try for the last time. I will try for the last time. I will not be able to continue like this. No, again and again doing the same. आप कभी अब देखो कुछ तो बच्चे क्लास में आते ही लेट हैं. See, there are how many problems. I tell you what is happening. Some people will join late. So if I have spoken for first 15 minutes, 30 minutes, they are not listening. So they will be utterly confused what I said. So there are many people like this. You never see where are the problems. If you are sincere student, please believe me. I am here to sincerely help you. नहीं करूंगा तो बताना. I will be blamed for it. I am ready to take the blame if I fail somewhere. But I will never fail. And I will not let you also fail. I will discipline you for your good sake. But don't disturb me in my class. देखो जब आप ये सॉरी वॉरी ना, with due respect, these are all now frivolous, false words. I don't believe in all these things. You commit 1,000 mistakes. Divyansh Mahajan is not for the first day in the class. You know it you know the teachers now mental background, you know the teachers now behavior, you know the teacher that what is. See, I am required to do this CPC in 55, 60 classes with utmost clarity. I am not required to pass time. कुछ भी पढ़ा के निकल जाओ. ये यूनिवर्सिटी तो है नहीं. There is no accountability. I am accountable. I am accountable to the institute. I am accountable to the students. I have to satisfy them. In simplest language, I have to teach them. So if you break my rhythm, if you do it again and again, अभी मैंने 15 मिनट पहले इस बात पर चर्चा की, फिर तुमने वही कर दिया. It means that you people are not serious. Some of you. Most of the people are very, very sincere, very, very serious. I love them. I respect them, their behavior. But there are some people who are not going to understand the things. You are in public life. It's class of so many people. Just by writing one thing can create chaos in entire class. That is what you are doing. अगर आप मुझे पढ़ाने नहीं दे रहे हो, the biggest issue is this. See, I have told you there are rules and regulations of everything. मैंने हर चीज का रूल बनवा दिया. क्वेश्चन आंसर सेशन होगा लास्ट में, आप पूछना ना सवाल. अब दूसरे व्यक्ति जो 2A पूछ रहे हैं उनको कल ही बताया गया, मैंने ऑफिस में बोला, डिड यू नॉट इन्फॉर्म दिस न्यू पीपल दैट दे हैव टू नाउ बी डिसिप्लिन्ड एंड देयर आर रूल्स एंड रेगुलेशंस, दे हैव टू फॉलो इट. हर चीज का रूल्स रेगुलेशंस होता है. क्वेश्चन मैं पूछूंगा आपसे, बीच में आप पूछ लेना. If you start writing like this, I did not understand, I didn't have 400 people will write, I did not understand one thing because they are. नहीं, forgive me नहीं. You have been told specifically in office that not to do it. Even then you have done it. So how can I accept this that you are sorry and you have mistakenly done it? I can't believe this. You waste my energy. You disappoint me. My performance will be affected, I must tell you. आप मुझे पढ़ाने नहीं दे रहे हो ठीक से. This is how SRA class has been hugely disturbed. Every time question, I was there in the class, and that created all confusion. I don't mind now people asking question, but now there should be some decorum. There should be some restriction, rule, regulation. I don't feel good. When I am not feeling good, when I am not happy, how can I teach well? I told you first day, if I remember correctly, are you happy? क्लास में माहौल ऐसा होना चाहिए सभी लोग खुश हों. Everybody should be happy. I learnt a lot. मजा आ गया आज की क्लास में, ऐसा फीलिंग आना चाहिए. अननेसेसरी पोकिंग, रेजिंग क्वेश्चन, ये जैसे विद्वान बन गए, ये ना अधजल गगरी छलकत जाए वाली कहावत सही है बिल्कुल. आई एम सेइंग इट वेरी कैंडिडली बिकॉज आई एम योर टीचर. जो लोग ज्यादा सवाल ववाल पूछते हैं ना, इसका मतलब उनका समझ कम है थोड़ा. अपनी समझ पे ध्यान दो ना भाई. रेज योर लेवल. आई एम रेजिंग माई लेवल एवरी टाइम. I read a lot before coming to the class. तुम भी करो, अननेसेसरी परेशान करना और ये करते रहना। 400 लोग लिखते रहेंगे आई डिड नॉट अंडरस्टैंड दैट, आई डिड नॉट अंडरस्टैंड दिस, तो क्लास चला। ये किसी भी क्लास में नहीं होगा। सर आपको क्वेश्चन पूछने का पूरा अधिकार है टुवर्ड्स द एंड। वो जो लिखते हैं ना इंटरेक्टिव क्लासेस और ये क्लासेस, वो क्या पढ़ाते हैं क्लास में आपको पता भी नहीं चलेगा। Legislature has expressly declared in Section 3 of Limitation Act Court said that legislature has explicitly declared in Section 3 of Limitation, देखो declared छूट गया, यही सब होगा। When I am not peaceful, I will be committing more and more errors. Court said that legislature has expressly declared in Section 3 of Limitation Act has especially declared in Section 3 of Limitation Act that whether the defense of limitation or exemption of limitation, defense of limitation is pleaded or not, whether the defense of limitation is pleaded or not, the court is bound to dismiss a suit. Court is bound to dismiss a suit which is brought after So if you bring a suit after limitation, your suit will be dismissed unless and until there is some exemption in law. Unless and until there is some exemption in law. Unless and until there is exemption in law. अब देखो आपने प्लेंट तो लिख दिया unless and until exempted, आप अपनी तरफ से ऐड कर दो। Unless and until exemption is allowed. Exemption means exemption from limitation. See, you may not understand many things in one go. You will understand everything. You will understand everything. Unless and until exemption is allowed. So this is now what is to be taken care of in writing of the plaint. Order 7 Rule 1 and Order 7 Rule 2 to 8. Is this clear? Is this all right? करो भाई, डिस्टर्ब करो क्लास को, मुझे कोई प्रॉब्लम नहीं है। अब आपने देख लिया प्लेंट कैसे लिखते हैं। अब देखिए ये प्लेंट का एक परफॉर्मा है जो आपके ऐप में डाल दिया है, जस्ट इसको देखते हैं। अब प्लेंट को लिखने का रूल हमने समझ लिया लगभग। वी हैव अंडरस्टूड द रेलिवेंट रूल्स ऑफ द प्लेंट राइटिंग। Specifically, we have understood Order 7 Rule 1 to 8 and we have also understood Order 6 Rule 1 2 and we have also seen Order 4 Rule 1 and Rule 2. These are the three relevant things which we have seen right now. As far as order 6 is concerned, we have seen other things also that you can look into again. Order 6. Order 6 relates to pleading. Now, we have said the relevant things. Forms of pleading, Appendix A में. Order 6 Rule 3 says that whenever you have to write the plaint, you can refer to Appendix A of CPC. अब घर पे, when you sit at home, please look into Appendix A. Just have a glance. Just have an awareness. Just have a look on the things which are there in Appendix A. There are 49 forms. Different kind of pleadings for different kind of relief, different kind of suits are there. So you just have awareness. Just inform yourself. So Order 6 Rule 3 says, the forms in Appendix A, when applicable and where they are not applicable, forms of like correct, as nearly as may be, shall be used for all pleadings. So this is for your convenience and comfort, that the code has given a kind of appendix where it says that you can look into that to write plaint. So plaint drafting is very easy for that matter. You have come to know the basic theoretical rules in Order 6, in Order 7, and you have come to know of the forms and performers also in Appendix A. Is this all right? On that basis, we will write that. Let us proceed further. Particulars to be given when necessary, Order 6 Rule 4. In all cases in which party pleading relied on any misrepresentation, fraud, breach of trust, willful default or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, particulars with dates, items, if necessary, shall be stated in the pleading. Now see, it's very simple. Now all these words which you write here, misrepresentation, fraud, breach of trust, willful default, undue influence, and in all other cases. Generally in contract law, we talk of misrepresentation, fraud, undue influence. On that basis, we can claim avoidance of contract in Section 19 of Contract Act 1872. Section 19 of 1872 Contract Act says that on this basis you can claim, because consent is then not free. Section 14 you might have read. I think Section 14 it is there, consent. So you might have read that consent is not free when it is caused by misrepresentation, fraud, undue influence, mistake, etc., etc. So if you claim relief of avoidance of contract, you will have to plead all these facts which are relevant there, even in similar other cases. So that is what is written, that if you claim relief on this basis, party pleading now relies on that he misrepresented the fact and he said this, but the reality was this. He committed fraud against me, he unduly influenced me, and then I wrote a contract, which is caused by undue influence. Section 16 of Contract Act, if you remember. So nothing great in that. On that basis, if you want to claim relief, you will mention that specifically. Yes, we will do that. Any condition precedent the performance or occurrence of which is intended to be contested shall be distinctly specified in his pleading by the plaintiff or defendant as the case may be, and subject thereto. An averment means a statement basically, of the performance or occurrence of all condition precedent necessary for the case of plaintiff or defendant shall be implied in his pleading. Condition precedent. What's the पहले आपको ये करना है फिर वो होगा. First this is to be done, then that will be done. So condition precedent. So that has to be mentioned whether it has been performed or not performed. If you do not perform your condition precedent, how can, like suppose I want some kind of agency of your company. Your condition is that you will have to deposit this much money as security deposit. So unless and until I deposit security money, can I claim against you that you did not perform your part? The answer is no. So if there is any claim or any relief based on such situations, such facts, will you not mention that in pleadings? The answer is yes, you will have to mention that. You understand it very commonsensically right now. Denial of contract, departure, bhai ye karna tha, nahi kiya. Denial of contract, effect of document to be stated, malice, knowledge, notice. No, these are nothing great. These are commonsensical things. Whenever it is necessary, I will bring this in picture. But you are not required to read them verbatim, but you should have a glance. भाई प्लीडिंग को लिखने में इन सब बातों का, लेकिन ये रूल्स ना, ये रूल्स हैं. They are not going to ask you question. What is Order 6 Rule 13? ये क्विज सेक्शन नहीं है. एग्जाम भी क्विज टाइप नहीं है. कैसे पूछ देंगे Order 6 Rule 13 क्या है कि आपको सारा याद करना है. Those who are new to the class, they must understand the questions are not framed like this. If they ask you any rule, if they ask you any order, it should be very, very important. Unless and until this is important, they are not going to ask you. So you should not try to read everything and remember and memorize everything. Sir, Rule 2A पढ़ाओ. Sir, ये Rule 11 नहीं बता रहे हो आप नोटिस के बारे में. अरे भाई ऐसे सवाल नहीं आते हैं. ये समझ जिस दिन आ जाएगा आपको, उस दिन आप एग्जाम तुरंत में पास करोगे. But this will take little bit time. Is this clear? अब नोटिस दिया है, नोटिस लिया है, तो वो भी मेंशन करो कब नोटिस दिया, कब क्या किया. In many cases notice is given. These are not so important. But Rule 14 and 15, what I said, Rule 14 and 15 is very, very important. You should keep this in mind. अब मैंने 14 तो नहीं बोला. मैं जो बोलूं उस पे ध्यान दो, मैं जो नहीं बोलूं उस पे ध्यान मत दो. What is Rule 14? ऐसे पढ़ने के लिए तो पूरा ज्ञान तो बहुत मिलेगा, आप पूरा पढ़ जाओ, सब कुछ पढ़ जाओ, हमें कोई प्रॉब्लम नहीं है. आई एम नॉट कंसर्न, बट दिस क्लास इज मीन टू फोकस ऑन दोज थिंग्स विच विल मेक यू जज. हमें आपको जज बनाना है, हमें आपको पारंगत बनाना है, हमें आपको कंफ्यूज नहीं करना है कि मैं पढ़ा दूं 100 रूल्स और आप समझो 10 भी नहीं. जैसे लोग पढ़ते हैं ना. I said in the first class that your focus should not be on input, your focus should be on output. Output basically refers to your performance in exam. And performance in exam depend on this fact that whether you understand the exam. If the moment you understand the exam and examiner, I think you are done. But people will not understand the exam and examiner. So it says, Rule 14 says, that is what is relevant for you, I am reading. Every pleading shall be signed by the party and his pleader, provided that where a party pleading is by reason of absence or for other ground, for other good cause, unable to sign the pleading, it may be signed by any person duly authorized by him to sign the same or sue or to sue or defend on his behalf. There may be a person who has been given power of attorney. There are many people who are given power of attorney because now those people cannot come to the court and they cannot do everything. So you appoint an agent for a particular case and you say that you will be doing all this. I authorize you to fight case on my behalf. So duly authorized agents are there. Power of attorney can be given. Every pleading shall be signed by the party and his pleader. Pleading shall be signed. Now a question arose in a case that whether it is necessary for the plaintiff to sign all memos, everything which is submitted by lawyer in the court. You present many documents, you present other thing. Should all papers be signed in the plaint or by the plaintiff? That is the question. That is the question. I framed a question, should all papers to be presented in the court be signed by the plaintiff? Plaint has to be signed and verified by the plaintiff. But all papers, all memos, is it so? Now, there may be certain situations where the other party can raise objection on this and can say that, see, this memorandum or this document or this particular paper is not signed by the plaintiff. But is it requirement of law? Let me tell you on this point that you must have seen whenever we file a case, we sign a wakalatnama. We give authority to our lawyer to prosecute and to conduct case on our behalf. A good lawyer, an honest lawyer will protect your interest always. And there will be presumption that all lawyers are honest. But there may be certain situations where lawyers may not do this. But generally we presume that whenever you appoint a lawyer, you sign wakalatnama and you give him permission and authority to conduct the case. So when this is the fact, that the plaintiff has given wakalatnama to a lawyer, then that wakalatnama gives him authority to sign papers on his behalf. And it is not necessary for plaintiff, it is not necessary for plaintiff to sign all documents. He is required to sign the main plaint along with the lawyer. But he is not required to sign all the documents every time. It is not required. It did not require now signature of party always. Always. It is not so. It is not so. वही मैं आपको पढ़ के बताना चल रहा, लिखा है every pleading shall be signed by the party. It doesn't say that all papers should be signed by the party. Every pleading shall be signed. Now rule 15. Save as otherwise provided by any law for the time being in force. Every pleading shall be verified at the foot by the party. So you will verify, or by one of the parties pleading, or by some other person proved to the satisfaction of court to be acquainted with the facts of the case. So the plaintiff will sign towards the end. The person verifying shall specify by reference to the numbered paragraph. मैं अभी आपको दिखाता हूँ. I'll just show you this in plaint. The person verifying shall specify by reference to the numbered paragraph of the pleading what he verified of his own knowledge and what he verified upon information. So there are two kinds of verification, on your own knowledge and on information received. Now I ask you a very simple question. You know the facts of the case because you are the plaintiff, you are the aggrieved party, you entered into contract, you gave the money, you supplied the goods, whatever it is. So you know, or lawyer knows this, you know it. So you have written here, the person verifying shall specify by reference to numbered paragraph of the pleading what he verified of his own knowledge. Order 6, rule 15 I am reading, sub rule 2. And what he verified upon information. Like now, lawyer says that this court has jurisdiction. Lawyer says that this suit has this much valuation. Something like that. So this is what is lawyer saying. You do not have knowledge. The verification shall be signed by the person making it and shall state the date on which and the place on which it was signed. So signature, date and place. The person verifying the pleading shall also furnish an affidavit in support of his pleading. Affidavit, that whatever he has ever and whatever he has said, that is correct. Is this clear? When commercial dispute has come in picture, then you have added many things here regarding commercial dispute. So similarly, this rule 15, a commercial dispute of a specified value. Whenever these amendments are there are nothing new. अब देखो ये rule 16 is striking out pleading, amendment of, this is a separate topic. So you cannot discuss it here. Amendment of pleading will come later on. We will discuss it later on. अब बहुत लोगों को भ्रम हो जाएगा, सर ने ये छोड़ दिया वो नहीं. अब आपको ये समझना पड़ेगा कि ना दिस थिंग्स शुड नॉट बी डन बाय यू एट लीस्ट. आप ऐसा नहीं करेंगे बिकॉज यू आर माई स्टूडेंट. यू विल अंडरस्टैंड द पॉइंट. अब देखो हम प्लेंट लिखने जा रहे हैं. अब आप इसके कुछ क्वेश्चंस भी बनाएंगे, बट यहां है प्लेंट in suit for a specific performance. How will we write the plaint? So you remember order 7 rule 1? You have written 9 points if you remember correctly. There is nothing great. Court is there. Plaintiff will go to court. Against whom? Defendant. Who is plaintiff, who is defendant, you will write that. If he is minor or unsound, you have to mention that. Then you have to say to the court that you have got the jurisdiction in this case. And I want this relief from you. I want this relief from you. If there is any property or anything like that, You will obviously specify to the court that you have got jurisdiction as far as territorial jurisdiction is concerned, as far as pecuniary jurisdiction is concerned, and then you will seek the relief. It should be competent court. It should be competent court. Then you will also say to the court that, see, that my suit is here, and I am, my suit is not barred by limitation. If it is barred by limitation, then I have got exemption. So any kind of point which is there in your favor to seek exemption from limitation, you will mention that. You will also mention that I want to have this set off, or I want to relinquish this claim. Relinquish means you are leaving it, you are waiving it. And set off means mutual adjustment of dates. You have taken 500 rupees from me, and I have taken 1000 rupees from you. So you have claim of 500 rupees against me because set off is there. 500 rupees is set off. Then the valuation of the property for this court's jurisdiction and as well as for court fee. So this is all which we are required to. Order 7, Rule 1. I hope this was there. Just let me check. Order 7, Rule 1. You do it yourself. It's very, very simple, by the way. But if you do not start doing, then cause of action. क्या लेके जाओगे वहां? Cause of action. So court, plaintiff, defendant, minor unsound, cause of action, then jurisdiction, then relief, then set off, and then valuation. So that is how it is to be done. Clear? Now see, when we write the plaint, obviously we will write order 7, rule 1 says, सबसे पहले क्या लिखोगे? The court. So whichever court is there, you will mention that. In the High Court of Judicature at Delhi, order 7, rule 1A, ordinary original civil jurisdiction. You know, now Delhi High Court had earlier jurisdiction beyond 20 lakhs. Now it has jurisdiction beyond 2 crores. Original civil jurisdiction. Up to 2 crores it is with district courts. It will vary from state to state. You are not required to memorize this. अब देखो, आप गलत गलत चीजों को यदि मेमोराइज करना शुरू कर दोगे और उस पर फोकस करना, your orientation will be lost. If I am appearing in Andhra Pradesh examination, I will look for Andhra Pradesh jurisdiction. If I am appearing in Tripura examination, I will look for jurisdiction there. It is your duty. I should not inform you what is in Arunachal, what is in Tripura, what is in Andhra Pradesh. This is not law. This is a factual thing which you can specifically look into the state wherever you are appearing in exam. You must know that. But that's your duty, not the teacher's duty. So somebody will write in the group also, can you give me a list of pecuniary jurisdiction of different states? This is not teacher's task, my dear friend. This is your task, whatever exam. छत्तीसगढ़ में क्या है, दिल्ली में क्या है, यूपी में क्या है, बिहार में क्या है, झारखंड में क्या है, हिमाचल में क्या है, पंजाब में क्या है, whatever. Karnataka, what is there, Tamil Nadu, what is there, Kerala, what is there, everything. Maharashtra, what is there, Chhattisgarh, what is there, MP, what is there. So you will look into that fact. Is this clear? But that is necessary to be written down in the plaint. So we start with court. So सबसे पहले सबसे ऊपर you will write court name. This is what is written in. अब देखो, order 7, rule 1A, यही तो है. You are not required to memorize anything. Those who understand, they do not memorize. And those who will listen to me carefully, they will never memorize. Then plaintiff versus defendant. So now you will write about plaintiff's address, defendant address. Order 7, Rule 1A, Rule 1B, Rule 1C. Is this clear? Now plaintiff, defendant, see, as far as plaintiff is concerned, you know your own address. But as far as defendant is concerned, you may not know exact details. That is why Order 7, Rule 1C says as far as, what is written there? See the words. As far as they can be ascertained. Is this clear? As far as they can be ascertained. Now, you write the name and you write, this is short cause title. In legal parlance, it is called short cause title. Long cause title, where you write complete detail, all facts, the name of the plaintiff, father's name, age, and other identifiable characteristics. In both cases, plaintiff and defendant. What will you write? Name, age, father's name, address, that is residence, and all other identifiable characters. Like in this ABC of Delhi, Hindu inhabitant, a coal broker residing in the fort. XYZ of Delhi, Mohammedan inhabitant, a cloth merchant residing outside the fort. So this is how the identification, he is residing in the fort, he is outside the fort. This is written in, now this is from Mullah's book, and where he has mentioned this. So this is very old per forma in that sense. I will send you other per forma as well. But this is beautiful one. Order 7, Rule 1A, Rule 1B, short cause title, a long cause title. Long, where you write the complete detail, long cause title. अब ये भी मत कहना ये भी समझ में नहीं आया. Short और long समझते हो ना? Short means this is brief and long means this is complete detail. This tendency of writing that I did not get it, that is why I asked this should be stopped. Everybody can understand anything. I have firm faith and belief in your competence and intelligence, and you are. Now you have to write the averments. So this is per forma, court name, plaintiff's address, defendant's address, defendant in Order 7, Rule 1C, plaintiff in Order 7, Rule 1B, and there's court name in Order 7, Rule 1A. Now then say, when plaintiff or defendant is a minor person of unsound mind, a statement to that effect. If it is so, we'll mention that as per Order 32, no? 32. There is no denial of this fact that even if a plaintiff is minor or unsound or defendant is a minor or unsound, they cannot be party to the suit. They can be made party to the suit. Only thing is that they cannot understand properly their own interest in the subject matter. So it is always better that next friend or guardian should be appointed on their behalf and he should contest the case rather than he contesting the case. Is this clear? You can have a glance of Order 32. Again and again you see, this is how you can remember. It says every suit, Order 32, Rule 1, every suit by a minor shall be instituted in the name by a person who in such suit shall be called the next friend of the minor. Next friend of the minor. Minor means a person who has not attained his majority within the meaning of Section 3 of Indian Majority Act, where the suit relates to any matter mentioned in clauses A and B of Section 2 of that Act and to any other matter. Alright. Next friend or guardian is basically a shield for his interests, no? So that is very, very important in that sense. Very, very important. And then it says in Rule 15, Rule 1 to 14 to apply to person of unsound mind. So Rule 1 to 14 relates to minority and then 1 to 14 will apply to insanity. Is this clear? Is this all right? Now you are required to write the plaint. See how it is written. By an agreement. Now I have said in the pleadings itself that every fact should be written in separate paras. And you plead only material facts, not immaterial facts. You plead only fact, not evidence. You plead fact, not evidence. You plead material fact, not immaterial fact. You write all material facts in separate paras. You write all reliefs in separate paras, and they should be properly numbered, and they should be written consecutively. 1, 2, 3, 4, 5, something like that. So it says by an agreement dated 1 June 2010 and signed by the defendant contracted to sell to the plaintiff certain immovable property therein described and referred to for the sum of rupees 3 lakh. A copy of the said agreement is annexed and marked A. Order 6, Rule 9, Order 7, Rule 3. Rule 3 relates to which thing? You just see it. Order 6, Rule 9 and Order 7, Rule 3. I have mentioned it deliberately for your proper understanding. मैंने इसमें जानबूझ के ये लिख दिया है. So you just have a glance of Order 6, Rule 9. Don't be in a hurry. Effect of document. Wherever the contents of any document or material shall be sufficient in pleading to state the effect thereof as briefly as possible, without setting out the whole or any part thereof, unless the precise words of document or any part. So you are not required to write the. यहाँ लिखा है ना, the agreement is signed by the defendant contracted to sell the plaintiff certain immovable property therein described and referred to for some of this. A copy of the said agreement. So we have mentioned, we have not written the details here. We have mentioned that there is an agreement to sell a particular immovable property, and copy of the agreement is annexed and marked A. Order 6, Rule 9 and Order 7, Rule 3 is obviously regarding immovable property. Immovable property. On 1 July 2000, the plaintiff tendered rupees 3 lakh to the. Now this is another fact. In first fact it shows that there is an agreement of June 1, 2010 signed by the defendant, whereby defendant agreed to do this for the sum of this. Agreement's copy is there. So in first paragraph you talked of agreement only. You just see the separate facts in agreement. What has been done in the agreement? That you have mentioned. Order 6, Rule 9 and Order 7, Rule 3, because it is related to immovable property. Immovable property. Is this clear? And you are not required to write exact details of everything. That is Order 6, Rule 9. Number 2. On July 1, the plaintiff tendered. Now this is another fact. On the basis of this agreement, I tendered payment of this amount. But defendant did not plaintiff tendered and demanded transfer, but the defendant has not transferred the property. So see, this shows that there is an agreement, the details of agreement. This shows that you did part of agreement. Now, in agreement, what is to be done? One party will pay and another party will transfer. So I paid, but he did not. So again, one point. There is an agreement, one. In agreement, I did this, he did not do. I hope you understand this. Plaintiff has been and is still ready and willing to pay the purchase money of the said property to the defendant. Plaintiff has been and is still ready and willing to pay the purchase money. So he just tendered, he has not paid it. All right, tendered, offered to make payment. So he says, plaintiff is ready and willing. As per Specific Relief Act, there is a requirement that if you want to claim a specific performance, then you are required to show to the court that you are ready and willing to do your part. See, I told you other day, if you remember correctly, those who have not heard me earlier, I tell them again, in drafting of the plaint, it's very, very important that you should know the law of the related provision, law of the related act. Now here I am claiming a relief of a specific kind, which is there in a Specific Relief Act 1963, as amended by 2018 Amendment Act. So I know that this is one of the requirement of the law, that one party should be, ready and willing to do his part, then only he can compel the other party to do this. 16C में पहले तो ये था, अब का 16C बदल गया है या देख लीजिएगा, स्पेसिफिक रिलीफ एक्ट का मुझे ध्यान नहीं है, but there is change now. But this is general. Even if it is not written in law, you will have to show that I am willing to perform my part, but he is not doing his part. And this is how the cause of action will arise. So if I do not know the contract law, if I do not know the Specific Relief Act, can I prepare a plaint carefully or beautifully or correctly? The answer is no. So I should know the law there. Plaint drafting will require lawyer's acumen. Drafting is a skill. It will be learnt by experience. In many cases, you may not be knowing that what to write exactly in the plaint if you do not know the law of the concerned subject. If you are now writing a plaint where you allege violation of certain building norms, rules, regulations, so you will have to mention that building regulation. If you do not mention that building regulation, that as per building regulation of this place, this particular provision is violated, how the cause of action will arise? How will you claim the relief? Just vague averments are not going to do anything. See, plaint is written for the purpose of court. So your duty is to give clarity to the court. What I said earlier also, that plaints are drafted in the chambers of the lawyers, which is to be pondered over and to be decided by the chambers of judges. So if you do not draft them well, you cannot convince the court. So this is what is required. This person knows that who is drafting, that readiness and willingness has to be shown on the part of plaintiff. Then only he can claim a specific relief from the other party. The said agreement was made in Delhi. Why we are writing this? We are writing this for the purpose of jurisdiction, and property is situated in Delhi. Section 16 says wherever property is situated, there the suit will lie. Section 20 says where cause of action arose, there the suit will lie. And the defendant resides in Delhi. So all the points of jurisdiction is written here. So just making false averments and unnecessary averments are not going to do. Now you can get relief only when you show to the court exactly that you have got jurisdiction. Otherwise, now if court is not convinced that they have jurisdiction, they will never entertain you. So be careful, you are required to show the court that there is jurisdiction in this court, and that is why I have come to this court. If you do not go to the court of competent jurisdiction, then the court is not going to give you relief. The said agreement was made in Delhi and said property is situated in Delhi and the defendant resides in Delhi. Agreement in. Now this is how you know. If you have read section 16 to 20 of CPC, you know this. If you have not read section 16 to 20 of CPC, So you may not write this exactly. How the court will get jurisdiction? So section 16 to 20 of CPC. Said agreement was made in Delhi. Said property is situated in Delhi. So you understand that for drafting of plaint, you are required to know the law related. If you do not know the related law, you cannot write or you cannot draft plaint carefully. And defendant resides in Delhi. The value of the subject matter of this suit for the purpose of jurisdiction is this. So this is now Order 7, Rule 1F, jurisdiction, no? You just check it. The fact showing the court has jurisdiction. The fact showing. अब देखो यहाँ पर fact showing that the court has jurisdiction, the fact constituting the cause of action. So 3 was related to fact constituting the cause of action, that I have done my part and I am ready and willing to do my part, but he is not. So cause of action arises. Cause of action. That is a cause of action. That is a reason of action. Why I have come to the court? This is the reason. See, I have an agreement. We entered into an agreement. I am doing my part, but he is not. So this is how cause of action arises. Point number 3. And this is how court has jurisdiction. Order 7, Rule 1F. You are not required to remember these things, and this is not necessary to be written down. This is just I am mentioning. You should not mention this Order 7, Rule 1F. I am mentioning for your understanding. Now, the value. The value of subject matter of this suit for the purpose of jurisdiction is how much? 100,000, 10,000 lakh. So 3 lakhs. Here it is not written, but you are required to mention this in amount, this amount in words also. Wherever you write anything, you have to mention this in words also. The value of subject matter of the suit for the purpose of jurisdiction is and it is same for the purpose of court fees. So court fee will be payable on that basis. Then it says the plaintiff will rely on document a list whereof is hereto annexed and marked. B. Marked A agreement. No? Marked A agreement. The plaintiff will rely on the document a list whereof is now plaintiff will rely on readiness and willingness. I had money in my account, you will show that. Plaintiff will rely to whatever document, on document a list whereof is hereto annexed. And marked B. Order 7, Rule 14. The plaintiff therefore prays. Now you are seeking a relief. Now see, Order 7, Rule 1. First you wrote the court name, then you wrote the plaintiff's description, then you wrote the defendant's description. Then you, if you have any now situation like that where he is minor or unsound, then you mentioned that. Then fact constituting the cause of action and when it arose. So here also on July 1, you see the time on July 1. Plaintiff tendered this amount, demanded transfer, but defendant has not executed. Plaintiff has been ready and willing to pay the purchase money of the said property. This is on the basis of a specific relief act. Fact constituting cause. So that fact which constitutes cause of action, that fact which shows jurisdiction, that daily where the property is situated, daily. This is on the basis of section 16 of CPC. You can see section 16 of CPC. You just have a glance. You just have a glance. See, your learning is more important. Don't be in a hurry. See here, subject to the pecuniary other initiation, for partition, for foreclosure, sale, redemption, for determination of any right or interest in immovable property. Can you see this? Shall be instituted in the court within the local jurisdiction of the property is situated. Section 16 says that court will have jurisdiction where property is situated. So section 16 is the relevant section of CPC which talks about jurisdiction. Is this clear? Section 16. And you see further, subject to the limitation, every suit shall be instituted a court within local limits. Section 20. The defendant actually involuntarily resides, carries on business or personally works for gain. So this is section 20. So defendant resides, or where the cause of action wholly or in part arises. The cause of action arises in Delhi, everything has been Delhi, contract is in Delhi, property is in Delhi, defendant is residing in Delhi, and he is not willing to perform his part in Delhi. So where the transaction happened, where everything happened, it is Delhi. Very simple. Delhi. We are required to be simple rather than being complicated, no? So fact showing that the court has jurisdiction, fact constituting cause of action and when it arose. So हर plaint में आपको ये दिखाना है कि how cause of action arises and when it arises. Then where the plaintiff is allowed a set off. No, we have not allowed set off, so we did not mention that. Or relinquishment of claim. And then the value of property. Is this clear? The plaintiff will write on the document a list whereof is here to annexed and marked B. Plaintiff therefore prays. So relief, the relief which plaintiff claims. Order 7, Rule 1G. Now see here it says the dependent may be ordered to transfer the said property. So first, order for transfer. A relief for transfer. I am writing in brief. Second, in alternative, defendant may be ordered to pay to the plaintiff as damages. That the defendant may be ordered to pay the plaintiff's cost of his suit. Cost follows the event. That is the law. So it is not necessary to mention. And then plaintiff's attorney and plaintiff. Then signature. Signature of both. Order 6, Rule 14. signature of both parties. He is the de jure author of this and he is de facto author, as he has written actually, but it will be filed in the name of plaintiff. Now it says, I, ABC, the plaintiff, above named, do solemnly declare that what is stated in para 1, 2, 3, 4, 6 is true to my knowledge. अब देखो, para 1, 2, 3, 4, 6 में क्या लिखा है? 1 में लिखा है agreement हुआ, 2 that I tendered this much money, that you know, still ready and willing, that you know, said agreement was made in Delhi, said property is in Delhi, you know, and 6, plaintiff will rely on document, that these are the documents on which I am going to rely. This is what you know exactly. And that what is stated in the remaining para, that is para 5 and 7, is stated on information and belief. And I believe the same to be true. Now, I believe the same to be true because value of subject matter for purpose of jurisdiction, it is same for the purpose of court fee. Now, this is not plaintiff's severment exactly. Plaintiff is not competent, he is not valuer basically. And he does not know about the jurisdiction of the court. That if this is the valuation, this court will have jurisdiction. He doesn't know this. He doesn't know this, that this court will have jurisdiction. So value of subject matter for this suit is this 3 lakhs and same is for the purpose of court fees. This plaintiff does not know. This is the lawyer's information. So that is why the language is changed. What is stated in remaining para is stated. So this is very important to understand for you. I don't know whether you understood this in your LLB or not. But this is very, very important for you to understand this, that plaintiff will write verification towards the end, do solemnly declare that what is stated in para 1, 2, 3, 4 and 6 is true to my own knowledge. Is true to my own knowledge, because I am party to contract. I have paid money or I tendered money, that is in my knowledge. Lawyer doesn't know this. I am telling him. I am ready and willing to pay 3 lakhs. That is what is I know. I was ready and willing even at that time. And I will be relying on these documents which may be in his possession. Then second, what is stated in the remaining para? What is stated in para 5 and 7? It is better to write like this. You always mention name, number of the para. What is stated in para 5 or 7 is stated on information and belief. And I believe the same to be true. Information and belief. Because this is not his knowledge, this is information. And this is what he believes, that the lawyer is giving him correct picture. This is verification clause. Solemnly declared at Delhi, Order 6, Rule 15, and then plaintiff will sign it. Plaintiff ABC, Order 6, Rule 15. Just go home, see some other performance, look to Appendix A also, and try to write like this. And there may be some question here and there in exam where drafting of plaint is asked. In many situation it is asked, especially in Madhya Pradesh, now even in Uttar Pradesh and in other states also. So you just start doing this. You just start doing this. Now, this is what is to be kept in mind in drafting of the plaint. Now suit A, suit B, suit B is money suit A is other suit. I have said already. Is this? I have already said certain facts that the point should be very brief and succinct, simple and straight. Active sentences, not passive sentences. I have already answered your or informed you that knowing the law before writing of the plaint is very important. No? Because then you can apply the fact situation in legal world, and that is how you can get the best relief. So that is to be taken care of. Now in the drafting of plaint, proper presentation of parties and proper presentation of claims and relief are also required to be understood. Also it is required to be understood, which we will discuss in order 2 and order 1, but not right now. Right now when we file the plaint, then there is next stage of admission of plaint, rejection of plaint, now return of plaint, because we are discussing the plaint, so we will discuss everything related to plaint first. So I will come to that in next lecture, admission, rejection, return of plaint. And we will bring some more questions here, we will bring some cases also. Now tomorrow I will be discussing with you many cases on the point. I must inform you, if you want to read it beforehand, let me tell you. So which cases I will be discussing tomorrow? Basically on rejection of plaint, I tell you order 7 rule 11. This is R.K. Roja versus केस होगा मेरे पास R.K. Roja versus U.S. Rayadu. Now I will be sending you this case in your app. R.K. Roja versus U.S. Rayadu and another. Division bench decision of Kurian Joseph and Fali Nariman. This is Supreme Court decision. This is Supreme Court decision. This Supreme Court decision which mentions many cases of 2016. Rohington, Fali Nariman and Kurian Joseph is the author of this decision. We will be discussing this. R.K. Roja versus U.S. Rayadu. Is this clear? And then this is Colonel Shravan Kumar. Shravan Kumar Jaipuriyar versus Krishna Nandan Singh. Colonel Shravan Kumar. अब ये सब case name is not important, I must tell you. Many people will have this belief that oh, अब ये सब केसेस का नाम भी ध्यान करना. आप अननेसेसरी प्रश्न रेज करके ना अननेसेसरी अपने आप को परेशान करते हैं. So you don't do it for God's sake. You are not required to remember any of the cases which I am mentioning. I will be discussing these cases only for information and understanding. You are not required to remember the name of cases. This is 2019 decision. This is 2000 M. Santa Gondar and Sanjeev Khanna. This was September 2, 2019 when this case was decided. It is there in live law also. No cause of action. Order 7 Rule 11. This is on Order 7 Rule 11. You will understand also little bit cause of action. And then I will also mention सलीम भाई. और एक केस तो इतना इंपॉर्टेंट मैं बताऊं आपको, वो केस हर जगह, एवरीवेयर दैट केस इज डिस्कस्ड इन लीगल सर्कल. जस्टिस कृष्णा अय्यर डिसीजन. Arivanandan, the name is I give you the name exactly. This is mentioned in a case. This is T. Arivanandam, T. Arivanandanam. Ariva versus Satyapal. And as you are reading this kind of procedural law, so case discussion will be very, very important. Case discussion will be very, very important. This is 1977 for SCC 467. This is very, very important decision of Krishna Iyer. So this is 1977 decision, and this has been never disputed, doubted by any court. So we are going to discuss all these cases because rejection of plaint is very, very important topic. Very, very important topic. So we will be discussing all these cases. Sir, please tell simply or in alternative. अभी तो आपने alternative relief देखा. And general, अब देखो, you cannot understand anything in isolation. It will come by experience. Sir, please tell me, मैं क्या बताऊंगा आपको? Simply means simply. Many things doesn't have exact explanation. You always ask question now which may not be relevant at this juncture. Unless and until you write the plaint, मैं आपको कितना भी theoretically समझा दूंगा, आप क्या क्या समझ लोगे? हाँ? Sir, please tell me this, please tell me that. I will tell you everything, don't worry. If plaint is rejected on this basis or not? कौन सा basis? अब देखिए ये रिजेक्शन पे चले गए. कितने विद्वान हैं आप लोग. अभी मैंने रिजेक्शन की चर्चा भी नहीं की. Now आप रिजेक्शन पे चले गए. If there is any exemption in limitation and plaintiff failed to mention it, is plaint rejected? अब plaint rejected पे आप सवाल पूछ रहे हैं ना. Plaint rejected तो अभी आप पढ़े नहीं. आप पढ़ दिए रिजेक्शन ऑफ प्लेंट. हैव यू रेड इट? यू हैव नॉट रेड इट, बट यू हैव ए क्वेश्चन बिफोर हैंड. तो 99% लोग, मैं आपको बड़ी सच्चाई से बोल रहा हूं, मैं भी एक विद्यार्थी हूं लॉ का ना. आई एम ए स्टूडेंट ऑफ लॉ. So many people who raise question, they either raise question in advance which will be coming later on, or they raise question which is somehow not discussed yet. So ज्यादातर सवाल ऐसे ही, आपको पेशेंस बहुत चाहिए पढ़ने के लिए. कुछ भी पूछ लेने से आपको विद्वान नहीं कहा जाएगा. पूजा दुबे, अभी रिप्रेजेंटेटिव करेक्टर सूट पढ़ेंगे आप. रिप्रेजेंटेटिव करेक्टर यही होता है जहां 10 लोग हैं, उसमें से किसी एक को केस फाइल करने दिया जाए तो 10 का वो रिप्रेजेंटेटिव हो जाएगा. दैट इज व्हाट इज रिप्रेजेंटेटिव करेक्टर. वेरी सिंपल. सेम इंटरेस्ट होना चाहिए, बट कब वो फाइल कर सकता है, नहीं कर सकता है, दिस इज डिस्कशन इन ऑर्डर 1 रूल 8. आई हैव टोल्ड यू, ऑर्डर 1 रूल 8. वैभव खट्टर, योर क्वेश्चन इज अनकॉल्ड फॉर, दिस इज नॉट टू बी डिस्कस्ड हियर. ये ऑर्डर 2 रूल 2 में है. देखिए सब फालतू सवाल पूछ रहे हैं. आई विल अप्रिशिएट ओनली इफ यू आस्क ए रेलिवेंट क्वेश्चन. अब ये जो पूछ रहे हैं ये भाई साहब, वैभव खट्टर साहब, ये ऑर्डर 2 रूल 2 में आता है. अब आपने पूछ दिया है ऑर्डर 7 में. अब ये डिस्कशन का पॉइंट है. अभी भाई साहब आप लोग क्वेश्चन जो है ना 90%, बुरा मत मानना बात, 90% क्वेश्चन बेसर पैर का है. अब बताओ ये है कि नहीं ऑर्डर 2 रूल 2 में? वैभव खट्टर, योर क्वेश्चन ऑन ऑर्डर 2 रूल 2. मैं सबको बता देता हूं ताकि लोगों को पता चल जाए कि वेदर आई एम करेक्ट और नॉट. अब इन्होंने जो पूछा उसके बाद पे ये क्या है, लॉयर और एडवोकेट ड्राफ्ट प्लेंट. ये क्या है अमरनाथ पांडे, क्या पूछना चाह रहे हो भाई? क्वेश्चन इन लॉयर और एडवोकेट ड्राफ्ट प्लेंट, क्या है ये? अच्छा पूजा दुबे, आपका क्वेश्चन जो है रिप्रेजेंटेटिव सूट का ऑर्डर 1 रूल 8। सेम इंटरेस्ट होना चाहिए। 10 लोग के बिहाफ पर एक आदमी सूट फाइल करे तो बेटर है। इफ ऑल 10 विल फाइल द सेम सूट, व्हाट इज द पॉइंट? शुभम चौरसिया, शुभम चौरसिया का जो सवाल है प्लेंट रिजेक्शन ऑर्डर 7 रूल 11 पर है, जिसका अभी हम लोग कल चर्चा करेंगे ना। इफ देयर इज exemption in limitation under order 7 rule 6 and plaintiff failed to mention it, so why will you reject this? I don't understand. Why will you reject this? ये तो कोर्ट की भी ड्यूटी है कि देखो भाई, आपको यही तो पढ़ा है सेक्शन 3 लिमिटेशन एक्ट में। हमें सिर्फ सवाल पूछना इसलिए पूछा गया है, ये सवाल है ही नहीं कोई भी सवाल पूछना इसलिए पूछ रहे हैं आप। सिंपली और इन अल्टरनेटिव ऑर्डर 7 रूल 7 देख लेते हैं भाई। चलिए ठीक है, अच्छी बात है। ऑर्डर 7 रूल 7 तो मैंने पढ़ा दिया, तो उसको देखते हैं। ऑर्डर 7 रूल 7 में क्या सवाल है जी? रिलीफ टू बी स्पेसिफिकली स्टेटेड, मैं फिर से पढ़ देता हूं। एवरी प्लेंट शैल स्टेट स्पेसिफिकली द रिलीफ विद द प्लेंटिव क्लेम्स आइदर सिंपली और इन अल्टरनेटिव। एक ही रिलीफ क्लेम की है, ठीक है, रिलीफ क्लेम कर लो सिंपली और इन अल्टरनेटिव। अभी तो पढ़ा अपने प्लेंट में, आइदर यू गेट स्पेसिफिक परफॉर्मेंस, अभी तो पढ़ा अपने प्लेंट में, हमने पढ़ाया तो वही अल्टरनेटिव है। ऑर्डर 7 रूल 7, it shall not be necessary to ask for general or other relief which may be given by general or other relief, जैसे cost follows event, वो general relief है, कोर्ट अपने आप देगा, आप मांगो ना मांगो। which may always be given as the court may think just to same extent as if it has been asked for, जैसे relief of cost follows event, कोर्ट अपने आप रिलीफ देगा, आपको मांगने की जरूरत नहीं है। जैसे लिखा ना अभी प्लेंट में भी आपको बताया, कॉस्ट का रिलीफ मांगने की जरूरत नहीं है, ये कोर्ट अपने आप देता। ऑर्डर 7 रूल 7। ऑर्डर 7 रूल 6 मैंने बता ही दिया। कोर्ट में परमिट द प्लेंटिव टू क्लेम एग्जम्पशन, ये भी लिखा है, नॉट सेट आउट इन द प्लेंट, सो व्हाई द प्लेंट विल बी रिजेक्टेड इफ इट इज नॉट क्लेम्ड, सो देयर इज नो रीजन। इज दिस क्लियर? अच्छा जी, आगे बताइए। प्लीज ट्रांसलेट सम इंग्लिश वर्ड्स इनटू हिंदी दैट विल बी हेल्पफुल इन एग्जाम ट्रांसलेशन। वाह, बहुत अच्छा, आई विल डू इट। वाद पत्र अभी बताया तो, वेरी गुड वेरी गुड। बट आपसे मेरा विनम्र प्रार्थना है, आप सवाल पूछने से ज्यादा हमको फॉलो करने में विश्वास करें, बड़ी मेहरबानी होगी आपकी। यदि फॉलोअर नहीं होंगे ना तो टीचर नहीं बन पाएगा आदमी। तो आप मेरे को फॉलो करो थोड़ा, वो ज्यादा अच्छा होगा। सवाल पूछना ये सब एलएलबी में चलता था खूब, सवाल पूछो, सर पढ़ा रहे कुछ, आप सवाल पूछ रहे कुछ नहीं। यहां ये सब नहीं चल पाता है, क्योंकि हमें एक ढर्रे पे पढ़ना है, हमें क्वेश्चन का आंसर करना है और सबको समझाना है। इज दिस क्लियर? अब देखिए, एक भाई साहब आगे, कोर्ट फी इज कैलकुलेटेड। इनको कोर्ट फी अभी सुना, अभी कोर्ट फी एक्ट नहीं पढ़ा रहे सर, हम आपको भटकने नहीं देंगे। अब आप कोर्ट फी में चले गए, हाउ इट इज कैलकुलेटेड, वेरी गुड, वो भी बता देंगे। अभी नहीं, अभी थोड़ा इंतजार करिए, अभी कोर्ट फी नहीं पढ़ना है हमें, अभी कोर्ट फी एक्ट नहीं पढ़ना है। ये टेंडेंसी को समाप्त करना, इधर से उधर उधर से इधर जाने वाली जो टेंडेंसी है ना, ये बड़ी गड़बड़ है। हम कोर्ट फी एक्ट तो नहीं पढ़ा रहे हैं आपको भी, हाँ? वो भी पढ़ा देंगे, हमें कोई फर्क नहीं पड़ता है। हम भी इसी बहाने कुछ कुछ ज्ञान अर्जित कर लेंगे। हम तो कोर्ट फी एक्ट पढ़ते नहीं, लेकिन पढ़ लेंगे आप कहेंगे तो। लेकिन वो सीपीसी का प्लेंट राइटिंग नहीं है कोर्ट फी एक्ट पढ़ना। आप कुछ से कुछ करना चाहते हैं, आपकी मर्जी है, आई कांट प्रोहिबिट इट, बट आई कैन सजेस्ट ओनली। कुछ से कुछ करने से आप नहीं बन पाएंगे जज। ये क्लास बहुत अच्छा नहीं चलेगा जब आप कुछ से कुछ करते रहेंगे। ये कुछ से कुछ की बीमारी को दूर करिए और सिर्फ सीपीसी करिए मेरे साथ, मेरी सीपीसी, सीपीसी विद रंजन। इज दिस क्लियर? सीपीसी विद रंजन and CPC with Ranjan's Act. Thank you very much. आपको मैं सिखा दूंगा क्वेश्चन पूछना भी, डोंट वरी, थोड़ा समय लगेगा मुझे अभी। So see you tomorrow. Bye bye. Why is the language of court not mentioned in? Does it play any role? Language, language का क्या करेंगे आप? कौन सा लैंग्वेज में लिखना चाहते हैं? डिस्ट्रिक्ट कोर्ट में तो हर जगह लैंग्वेज अलग अलग होता है, तो यहां लैंग्वेज लिख के क्या करेंगे आप? हैं भाई, जिस स्टेट में रहोगे वहां की भाषा में लिखते हो ना आप चीजें, हिंदी में, अंग्रेजी में, नहीं? Different states have different kind of language and they will write differently, and that will be basically helpful. You know, All India Judicial Services में आज तक ये बहुत बड़ा concern है. When we have this All India Judicial Services, now then how will address the concern of regional languages, because justice may not be done in that case, because people will not have idea of regional language. And you see, in many judiciary you ask हिंदी मीडियम की क्लास भी शुरू होगी, डोंट वरी. यहां हिंदी में नहीं समझाना है हमें, हम हिंदी बहुत बोलते हैं, जरूरत से ज्यादा किसी भी चीज की उम्मीद ठीक नहीं होती है, नहीं? अब हिंदी बोलने लगे, हिंदी बहुत बोलते हैं हम क्लास में, तो क्लास खराब हो जाएगी हमारी. ये अंग्रेजी भाषा क्लास है ना, तो आपको भी समझना पड़ेगा. बहुत हिंदी बोलते हैं हम, अपने से भी थोड़ा करिए, मदद लीजिए. बहुत हम सिंपल इंग्लिश भी बोलते हैं, बहुत सिंपल हिंदी भी बोलते हैं, कोई बहुत कठिन नहीं है. बट आप बिल्कुल नहीं पढ़ के आए हैं तो थोड़ा सा समय तो लगेगा. 2-4 महीने में पारंगत हो जाएंगे आप. कोई भी हो जाता है पारंगत, मैं भी हो गया था इसी तरह से, एक साधारण विद्यार्थी था. अब आपके सहयोग से मैं भी एक अच्छा शिक्षक कहा जाता हूं. सो यू विल बी ऑल्सो गुड, डोंट वरी.